Guys, good morning, good morning, good morning. Welcome to Take It to Trial. Hope everybody's doing great this morning. Thanks for joining in and welcome back. We are continuing with Ronny Walker with the death penalty phase, right? So he was convicted of first degree premeditated murder of Nylexia Alexander on Monday. And now a jury of 12 is going to decide whether he lives or dies. Thank you all for tuning in. Definitely put your comments in the chat room, whether you think that the defense is going to present enough evidence to not convict him and sentence him to death, or does he get life in prison? Remember, you're definitely in the right place where there are no filters, no fluff, just facts. Let's take it to trial where you can be the judge. I'm going to put us immediately in the courtroom. Let's get over there.
With those additional acts that are unnecessarily torturous and conscienceless and pitiless. Then you have the issue of gunshot wounds in the case law that emphasize that normally they are not especially heinous, atrocious, and cruel. So I submit there is no evidence that she knew she was about to die. No additional acts presented. That's just the evidence. That's where we are. No evidence he intended to have her suffer or inflict a high degree of pain. Plus, the medical examiner also testified there were no defensive wounds, and that is important as well because some of these cases talk about that as, of course, contributing to especially heinous, atrocious, and cruel. Judge, the evidence is just not there. Again, if this is found to be EHAC, then every single shooting will be. Thank you, Judge.
Can you distinguish on page 29 of that Gonzalez case where the court mentions that the victim's mental state, and the victim's perception of imminent death need only last seconds for the aggravator to apply?
Well, that's one thing the court is saying. If that's what they're saying in Gonzalez, and I saw that in Gonzalez, sure. That's not saying, oh, that means that it only means that. That's one quote by the court in that the victim knowing. So in other words, it's kind of similar to, as I mentioned, the Jimmy Rice case, where, the guy, Mr. Chavez, has the gun, and he says to the victim in a few seconds, do you want to die, or you are about to die? So that is just I don't necessarily disagree with that. That is just a quote in Gonzalez about the time period in which the victim felt the apprehension.
So your argument is in Gonzalez, all the other factors in conjunction with time makes the difference.
Oh, absolutely, absolutely. Because if the Florida Supreme Court is making that one line quote in Gonzalez saying that period of time can be a few seconds, okay, that's what they have stated by saying that. But in Gonzalez, that is the one where you have the shot into the floor, you have the shot into the leg, you have the shot into the other leg, and you have the victim terrorized. Gonzalez led that person into the bedroom. So if all of that is happening quickly, so that is just one line in it. They're making that comment that, hey, that apprehension and the victim being aware could just merely last seconds. But again, that is only one of the factors. We have to look at Mr. Walker's intent to cause unneedless suffering. This has to be wicked, shockingly evil, or vile, that he designed to inflict a high degree of pain. So we're not just looking at Miss Alexander, even in those few seconds. That is just one line in Gonzalez. Again, there has to be additional acts to show it was conscienceless and pitiless and unnecessary torturous. So Mr. Walker is there evidence that he has utter indifference to or enjoyment in the suffering of others? That issue of just a few seconds? And I don't necessarily disagree with that one line. And of course, it doesn't even apply in Gonzalez because of what happened. But that's just one part of it. And honestly, we don't even know. The thing with this case is you just don't know. So no, yes, Judge, that is clearly distinguishing.
Judge, just one thing I point out, she keeps saying heinous, atrocious, and cruel. It's heinous, atrocious, or cruel. You don't have to prove every single one of those things. And the fact that she knew of her impending death is a super strong indicator of cruel, Judge. And we believe these cases are not really that distinguishable. In each of these cases, a victim is shot once and then moments later executed, similar to here. And the courts are finding that those situations in which a victim is shot once and then later shot again, a short period of time later, that's heinous, atrocious, and cruel. That's what we have here, Judge. I agree, if we could not establish the sequence of the order, we would probably not have alleged this particular aggravator. The fact is, we can prove the sequence of the orders, and we can prove that the first shot she received was not a fatal shot. She was alive, she was in fear, she was in a place she had no idea where she was, because she'd been taken there by this man. She gets out of the car, she walks away from the car, so clearly has ability to move, knows what's happening, and clearly knows death is right around the corner from the man who just shot her and is now getting out of the car himself. So all of that, Judge, is consistent with all of these cases in which you have an individual who was shot and then mere moments later executed, and the courts have found that the knowledge of the impending death is what makes it AJC. So that is why we believe this case does qualify and it should be a question for the jury.
Let me ask you this, Mr. Perry. I'm going to find this. Rivera v. State, 545 Southern 2nd, 864, Florida Supreme Court. In that case, an officer of the law was murdered. 2 shots were fired within 16 seconds of each other. And despite the fact that the officer was shot while kneeling on the floor with his hands upraised, the court found that that was not hacked. So how do you reconcile that with Rivera without recognizing the fact that in Rivera, the victim had witnessed her husband or her significant other being shot twice and then executed before she was shot. So while the court may say mere seconds, but there was quite a history before the second victim was killed in Gonzalez.
In that case, Judge, he was shot and killed pretty much instantly. In the case
But if you look at
the law enforcement officer,
if you look at the language preceding the line on that page where it talks about only mere seconds is fine, and it talks about the common sense understanding of witnessing someone getting shot twice and executed had some effect on that victim as well, mere seconds, but it's not, I don't think it's taken in isolation. And it's hard to.
And I agree, Your Honor, there are cases, we could sit here all day and go back and forth on cases because it is such a close call. But one of the things that I believe the courts take very seriously is this knowledge of impending death. And I'll go back to Phillips v. State, in which this individual was stalked. In the same sense, quite honestly, our belief is, Alexi Alexander was stalked by this individual when he was looking around trying to find her. Okay, shot twice in the chest and then fled a short distance before being killed by repeated shots in the head and neck. I don't see how we can distinguish this case from that case.
And which case is that again?
That's the Phillips v. State case, Judge, 476 Southern 2nd 194.
Okay.
It says the trial court correctly surmised that between 2 volleys of gunfire, the victim must have agonized over his ultimate fate and properly considered the circumstances in the sentencing process. I don't see how it's any different than what the situation we're talking about here. And again, Judge, we could go be pulling up cases literally all day long. I can't tell you how many cases there are on AJC in the state of Florida. And slight little tiny differences will distinguish each one. But one thing that seems to be consistent, especially when it comes to gunshots, is that if there is a delay between the first shot and the fatal shot, that generally will fall under the AJC, almost always. At least everything I've read. And so I tried to pull out some of those cases that I saw that seemed to be indicative of that. And here we have that exact same thing as we have in Phillips, where you have a person stalked, and then shot twice in the chest, fled a short distance, which is kind of what we have here, Judge. I don't see how it's much different. And then killed by repeated shots in the head and back. And again, the finding in this was that the trial court correctly surmised that between the two bodies of gunfire, the victim must have agonized over his ultimate fate. And that's the state's position in this case, Judge. Alexia Alexander was shot, and in those 9 seconds clearly must have agonized over her fate because she knew she was in a horrendous situation and she was going to be killed. And so for that, Judge, we cite Phillips, and we believe that we have it at have a case of heinous, atrocious, or cruel.
Judge, it keeps talking about she knew of her impending death. There is more than that right in the jury instruction. And Phillips, they even said the victim fled 100 feet. So they had the evidence. We don't have that. We don't know any circumstances after getting out of the car. We know nothing.
I mean, honestly though, your assumption that the first shot didn't incapacitate her was based on the blood trail and things, but she could have been removed from the car by Ronny Walker.
That's not what Robert Creed said, Judge. You gotta take the two in concert. Robert Creed's testimony says she was shot in the car, grabs her chest, ordered out of the car. She gets out of the car on her own volition and walks out by herself. And then he sees Ronny Walker gets out, and then a few seconds later he hears gunshots.
Right.
So what I'm saying is that the physical evidence corroborates what Quincy Creed said occurred. So that's why we're saying we have proven that, Judge. It's not an assumption. This is what the state's position is. We have proven that beyond a reasonable doubt.
If I could just correct Mr. Terry on one thing, he said that after being shot, Creed indicated, Mr. Walker said, at that point, get out of my car. That is not what the evidence was. It was prior to that. They had the argument, are you having sex? No. Then Mr. Walker says, get out of my car, then the first shot. So I just wanted to clarify that.
Okay, Judge, I think that's regardless of that. I'm just saying,
I understand.
she got out of the car of her own volition, her own abilities, and was not dragged out, was not pulled out, was not carried out. She got out and was walking and bleeding, which means the only shot that it could have been was the one to her back.
I understand. All right, so I'm gonna reserve it out for a moment what is the next issue?
So the next one?
The next issue.
Yes. All right, so my motion also includes cold, calculated, and premeditated without any pretense of moral or legal justification. For the record, I want to read in the jury instruction, and this is 921, 161, 6I, of course. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. I'm going to concentrate and leave that part out of the moral and legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent and the killing. The period of time must be long enough to allow reflection by the defendant, and the premeditated intent to kill must be formed before the killing. And of course, that is the definition for premeditated murder. However, cold, calculated, and premeditated is different. It is a heightened premeditation. However, I'm continuing with the jury instruction. For this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. And then it goes on to, and I will read it into the record, a pretense of moral or legal justification is any claim of justification or excuse that, although insufficient to reduce the degree of murder, nonetheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. So going to the facts presented on that. All right, so I want to take the court back to the compilation video, and if the court wants to look at it again, because I watched it several more times. We have Miss Alexander, first of all, walking. Of course, we know there's no contact with Mr. Walker. We know it is with Mr. Creed. We have her walking in a very, very lit apartment complex. She's looking down at her phone. She has the charger around her neck. Very well lit, to the point that the police have flashing blue lights in that area. We then have her getting into a vehicle. That is also well lit. The car's lights remain on when it is sitting there in this well-lit area, picking her up, lights still on, and prior to that, you see the court drive headlights on. So then she is picked up. The vehicle drove along with, headlights, never, not shutting off his lights. There was testimony that it was only 1.3 miles from the location to where she was picked up to the location off Florabraska and Highland. Now, the video from the corner of Florabraska and Highland, which is the one with might potentially be a spider leg across the camera, the timestamp is off. However, my sequence of discussing it, even with the timestamp wrong, satisfies what I need to talk about. The car is first seen at 2:59 and 21 seconds coming down Highland with its headlights on. The vehicle then turns down Florabraska, still with its headlights on. The car goes down a short distance out of view. We know down there further is a dead end, because that part of Florabraska is a dead end. That car did not sit at this dead end. There has been so much talk about this being a dark, isolated, and desolate area. This is not an orange grove. This is not fields off the interstate. The car goes a short distance, goes out of sight, and must make a U-turn where that dead end is, and comes back. It is not in the dead end. It comes back and parks in front of a lot that doesn't have a house on it. This is a residential neighborhood. This is not some desolate, isolated area. If Mr. Walker planned on murdering her and wanted to murder her, why doesn't he take her off to some field? Why does he take her to a residential neighborhood? He could have sat back in the dead end. He didn't. He made the U-turn and parked in front of where there was not a house for that area. So the headlights at that point do not go out until the vehicle parks there. The vehicle parks there 3:00 and 4 seconds, and again, that's off, but for my purposes, the timing works. 3:00:51. So presumably in that time period, we have the shooting, 47 seconds, as we've mentioned before. The lights then go back on because the car is now going to move. It goes back on. The headlights briefly flicker off, and then they go back on. So 1.3 miles. The testimony, Detective Whelan said it was not far from the location where she was picked up to the scene. The vehicle is never at any time from that video itself at that dead end. He is not. He is more towards the intersection of Florabraska and Highlands. Alan Wallace, who lived in the neighborhood and was studying for the bar, saw the vehicle. He testified that the vehicle's lights were on, and in fact, they were shining into his window, and it disturbed him while he was studying for the bar. His comment was the car was, quote, in the middle of the street. Yeah, it's at the middle of the street, right off the intersection of Florabraska and Highlands, because it went down, made a U-turn, and came back. This is not taking place at the dead end. And it could have been. First of all, you wouldn't take her to a residential neighborhood, and you could have stayed in the dead end. State's Exhibit 36B, the overview of the area, Your Honor can clearly see it's a residential neighborhood. There's houses in the front, there's houses on that road. It is a residential neighborhood. I'm looking at all right, Eric Walker. There were several people out in the area that night. He heard the shots, he went to investigate. He's knocking on doors because it's a residential neighborhood. He's looking for ring cameras. His testimony, there was a fair amount of people out and about. Officer Abby Pittner from the Tampa Police Department said the area is an empty lot. Yeah, because there's not a house on it, with houses surrounding it. The state called many neighbors who had cameras, because there are all houses on this street. Detective Whelan described the area as, quote, a residential neighborhood. Mr. Creed did not testify, actually said he didn't know Mr. Walker had a gun, so we don't know anything about that. Mr. Creed did not testify to any comments of, I want to kill her, I'm going to kill her, I have this plan, absolutely nothing. What happens is, apparently Mr. Creed arranges to meet her, presumably, because we know it's not Mr. Walker. And there was some comment by Mr. Creed about he was looking for the girl, period. That's it. Not he's looking for this girl to kill her, not looking for this girl to get back at her, not looking at this girl to hurt her. And that's after they were driving around so he could look for a girl for Mr. Creed, presumably to do something with. So there was nothing said, no threats to kill, just that he was looking for a girl. Where is this careful plan? Where is this heightened premeditation? And we know the argument, and the argument is critical, because when you have the case law and you have the jury instructions, when there's an argument, the argument started over the sex. Mr. Walker, after Alexei Alexander says no, he says, get out of my car. An argument is frenzy, it's rage, it's impulsive, it is taking place at that moment. That is not cold, calculated, and premeditated with heightened premeditation just because they picked up Miss Alexander when only 1.3 miles. I've described the car already, and there's absolutely no other evidence. No evidence of harms or threat to her. Mr. Creed never testified that Miss Alexander ever crouched down. This goes, I guess, to the EHAC argument as well. He never testified that he saw her crouch down and turn to her side. If that, in fact, is what the state will continue saying about premeditation. We've got to have that heightened premeditation. Stanley Wilson. All Stanley Wilson recounts is a conversation allegedly afterwards. Yeah, she gave me an STD. Apparently, I guess that's why he shot her. That's not premeditated. That's something said after the fact. He didn't testify to issues or arguments that Mr. Walker said to him, I'm looking for her, I have to get her, we had an argument. He never testified, or neither did Mr. Creed, or no other evidence, to a careful plan or prearranged design to kill her. There is no evidence in the record, Your Honor, of a careful plan carried out with the heightened premeditation. The jury has found premeditation, but to have the code calculated and premeditated, you have to have that heightened premeditation. What we have is an argument, an impulsive argument, and then an act after that. That does not rise to the level of heightened premeditation. There is absolutely no evidence of that. There was some evidence by Mr. Wilson. They knew each other, okay? That is not a plan to kill, a careful plan prearranged to kill with substantial cool reflection. It just doesn't exist. By the way, there was never any evidence presented. The state keeps saying lured. He lured her to her death. There was not one shred of evidence that he lured her or lured her into that vehicle. Again, as the state did with especially heinous, atrocious, and cruel, they want to speculate. They want to assume. We need evidence. We don't have any knowledge of them communicating. We didn't have any evidence that some comment was made in closing argument, Miss Alexander could trust Mr. Walker and that she put her guard down and because he was, quote, luring her. There's no evidence of any of that. That was pure argument. And again, where we have the vehicle, we have painted this picture of some desolate area. These cases talk about what a desolate area is. That vehicle was parked just short of the intersection of Highlands and Nebraska. Could have stayed at the dead end, but did not. A couple of cases, they pretty much talk about what you have to have for the code calculated and premeditated. Let me, just for the record. And then I will go to Mr. Terry's cases. All right, for example, I cited the Victorino case, 23 Southern 3rd 87. That is an extreme example where the aggravating factors were, of course, shown. I'm sure we're all familiar with the Victorino case. That is the Xbox murders on the east coast of Florida. But the court talks about the enunciated four-part test for the application of that aggravator, and it is the killing being a product of cool and calm reflection, and not an act prompted by emotional frenzy, panic, or a fit of rage. And the defendant must have had a careful plan or prearranged design to commit the murder before the fatal incident. The defendant must have exhibited heightened premeditation, and there must have been no pretense of moral or legal justification. The Wyndham case in my motion, 656 Southern 2nd, 432, it cites the Richardson case. Again, with this aggravator as well, I'm sure Mr. Terry would agree, we could also be here all day long with facts. We don't have the facts and evidence in this case, but it cites Richardson, where they did not find those elements were proven. We just don't have the evidence. I'm checking if there was anything else. Where was it? Okay, so Mr. Terry's cases. Mr. Terry cited 4 cases of cold calculated and premeditated without pretense of moral or legal justification. Those cases are extreme cases where it kind of looks like CCP applies. So first of all, we have the Baker case. Baker walked around till he found a house to rob with his co-defendant. He then held the victims at gunpoint for 2.5 to 3 hours. They could have been planning during that time. They searched the entire house. They kidnapped one of the victims and made them go to an ATM. They went to a, quote, rural area. That is not what we have. They couldn't get money or something at the ATM, and it ends up that the victim starts running and is chased. That is an example of cold calculated and premeditated. That is clearly not what we have. The Wright case, which is WRIGHT, that's a carjacking. The defendant in that case said it cannot be cold calculated and premeditated if he's under extreme duress. Then the court went on to some of the facts. There was an abduction in that case, and the victim was executed. 2 witnesses described what the defendant told them about the murder, how he lured the victim, and how he carjacked the victim. Distinguishable. The next 2 cases are all kidnapping cases. Calhoun. This one is interesting. The victim is bound, put in the trunk of her car, driven to the woods. The car is doused with an ignited fluid and left to die from smoke inhalation after a fire starts on the car. So that is showing an intent to kill, a heightened premeditation after a kidnapping and all those acts. And finally, Thompson is also a kidnapping. The victims were driven to an isolated area, which we do not have. After the defendant walked into the office, I believe like a cemetery, with a gun and a knife. And after he walks in, he has them lay down on the ground, and the case continues on about the facts in that case. Those kind of seem like cold calculated premeditated. That is not what we have in this case, Your Honor. And we ask that you strike that as a matter of law, because you are the trier of fact and know the case law. Thank you, Judge.
Mr. Terry.
Yes, Your Honor. So, Your Honor, I believe this is clearly a case of cold calculated and premeditated. We have an instance where we have an individual who says he was looking for her, clearly had a plan to find her. He then located her. He then drives her to this location, Judge. And I know Mr. Lemmer keeps wanting to say it's not isolated. This is the middle of the night. She leaves out that part of it. Okay, this is 3:30 in the morning or 3 o'clock in the morning. He drives there. It's a dead end street where he turns around, and he does turn the lights off as soon as he gets there. He also places his vehicle, Judge, and I think this is very important. Mr. Lemmer mentioned it. He pulls the driver's side of the car up to that vacant lot. He didn't park at any other location around there. He didn't park in front of a residence. He didn't park on like right next to the corner. He parked right next to that vacant lot. Why would he do that, Judge? Because it's a spot where he could easily dump her by. This was an intended plan he had thought of and planned to do from the very beginning. He took her there. He obviously armed himself. Okay, that's one of the factors that's considered in this. He's a felon, so he had to find a way to get a firearm and got a firearm, armed himself, found her, drove her to that location, which obviously in the daytime, it might be a different situation or a different scenario. We're talking night. Even Mr. Creed said it was incredibly dark there. Couldn't see anything. There were no street lights. He then pulls up there, asks her a single question. All we know is he said, "Are you having sex?" And she said no. And then he says, "Get out of the car." There's nothing else about any sort of an argument, anything like that, just that he was upset with her for having sex. And we know from, I guess, Stanley Wilson that, at least if you believe him, that it was because of an STD. Either way, Judge, he then follows her out of that car. She gets out of that car, granted after being shot. He could have driven away. Again, there's case law about that where they could easily get away. There's no reason to continue on with this, but he did. He continued on and he went and he executed her, Judge. And that is execution style killings are by definition cold. And that's in every single one of these cases I cite. So Judge, I think this is very similar to all of these. Where a defendant has the opportunity to leave a crime scene with the victim alive, but instead commits the murders. Those are things that are found by their very nature. Execution style killings satisfy the cold element of CCP. The calculated element applies in cases where the defendant arms himself in advance, kills execution style, plans his action, and has time to coldly and calmly decide to kill. When he got out of that car, Judge, he had 9 seconds to decide what he was going to do. And he walked up to that young girl and shot her in the head. That is cold, calculated, and premeditated. Again, all of these cases I cite, they drive to remote locations or isolated areas. And again, it's the state's position that this does qualify. Granted, it's not an orange road miles and miles away, but it is a dark, secluded area with in a vacant lot and a field, basically, where it's an easy place to leave a body. I was citing there Wright v. State, 1973, 277. Again, in Baker v. State, 71-7-3-802, execution style killing is by its very nature a cold crime. Again, it says the calculated element applies in cases where the defendant arms himself in advance, kills execution style, plans his actions, and has time to coldly and calmly decide to kill. A plan to kill may be demonstrated by the defendant's actions and the circumstances surrounding the murder, even when there's evidence that the final decision to kill was not made until shortly before the murder itself. That's another important aspect of this, Judge. There's no time limitation, okay? Here it says it may be demonstrated by the defendant's actions and the circumstances surrounding. It's the state's position, Judge, driving her to this location where she's not, as far as we know, she's unfamiliar. It's dark. It's a vacant alley or vacant lot, and he pulls up there. The way he pulls up there, all of that shows a plan, a place to put her, and at least put her body after he kills her. And again, these cite other things, including the fact that they had ample opportunity to release the victim, but instead, after substantial reflected, acted out the plan he had conceived during the period in which the events occurred. And so, let's see. In Baker also, because the victim was shot in the forehead at close range, the physical evidence is thus consistent with an execution type killing, in case there's any question about whether or not this was execution style. Again, Calhoun v. State, 138, Southern 3rd, 350. Manner in which defendant executed the crime is important. Where a defendant arms himself in advance, kills execution style, and has time to coldly and calmly decide to kill, the element of calculated is supported. Taking a victim to an isolated location or choosing an isolated location to carry out an attack can be indicative of a planned or prearranged design to kill. Exactly what the state is arguing in this case, Judge. Exactly what the facts seem to indicate. So that's why we cited that case, which was Calhoun v. State, 138, Southern 3rd, 350. And then in 648, Thompson v. State, 648, Southern 2nd, 692. Again, Thompson took the precaution of carrying a gun and a knife with him to the cemetery office. After he had obtained the check from SWAC, he drove the victims to an isolated area, forced them to lie on the ground. There's no indication of any resistance. Again, there's no indication that Alexei Alexander resisted in any way. And again, advanced procurement of a weapon, lack of resistance or provocation, the appearance of a killing carried out as a matter of course. Judge, I believe the state has proven all of that by the facts and circumstances surrounding the killing, the location where the killing took place, the execution style killing. And Ms. Fawcett has provided me another case that I did not. It's called Squires v. State, 450 Southern 2nd, 208, which states shooting victim 4 times in the head with revolver after initially wounding victim with a shotgun and firing 4 shots at extremely close range indicates CCP. So Judge, based on all of that, the state believes we have established more than enough facts to prove beyond a reasonable doubt to the jury that this is a cold, calculated, and premeditated murder.
Yes.
Yeah, Mr. Terry is incorrect when he says there's no street lights. On that corner of Flora, Nebraska and Highlands, where the cars park, I guess I don't know if it's south or west, but short of the intersection, you can see the street lights on. So that is absolutely not true. He also misspoke when he said Mr. Creed never talked about an argument. Yes, he did. He said that when they talked about the sex, he got mad and there was an argument. So that was the testimony. Mr. Terry is using a comment about that was not in evidence, and that is, oh, Mr. Walker was a convicted felon. That did not come in. That is not evidence. All we know is he was looking for the girl. That's it. And that's after he was looking for a girl for Mr. Creed. I also take the fact that he parked the wrong way interesting, because not only is he shining his headlights into Mr. Wallace's home, not ending up in the dead end where he could have, but actually parking the wrong way on the street is indicative of being, hey, maybe someone will see this. Why is this car parked the wrong side of the road? He keeps saying, Mr. Terry keeps saying, executed, executed. We do not know anything about Miss Alexander's condition once she is either carried, taken out, walks out of that vehicle. So we don't know execution. We don't know if, we just don't know any facts. So the continuous use of the word execution. He made an interesting comment too. He said, as far as we know, she was unfamiliar with the area. We got to look at the evidence. And the evidence in this case does not support it. We were not provided the last case, but I can tell you that talked about a shotgun being used first, I believe, and then a firearm after that. So, Your Honor, this does not rise to that level. Premeditated for the jury to have returned a first-degree murder, but does not classify for that heightened premeditation for this aggravator to apply, and we're asking you to strike it. Thank you.
I'm going to reserve on that momentarily as well, while I ask if there's any other issues we need to discuss. Any other issues we need to discuss?
Yes, unfortunately.
All right, let me get a timing on this, because that jury's been back there for 45 minutes now almost. So how much longer?
So we have to talk about a situation and another motion I filed to exclude the testimony of Raymond Lee and the prior violent felony. I think that's pretty much, it's not really any issue. Do you have anything? Oh, and the victim impact judge. We were supplied with victim impact late yesterday afternoon. I have taken a look at them. Overall, they're very good. There's only a few couple lines that, for the record, I want to object to. So that'll only take a couple of minutes.
Overall, how much time do you think?
Those two issues, 15, 20.
For everything?
Oh, we also have a problem, because if the court does not exclude Mr. Lee, but you will hear about this, we need to be able to depose him. But I have to explain to you why and what happened.
All right. All right, court will be in recess for 5 minutes, and we'll address those issues and try to figure out what to do with the jury.
Court stands in recess.
Hi. So what do you guys think so far? Is the prosecution case strong, or let me mute that part over there so we don't have to hear that part. So what do y'all think? Is the prosecution putting up, well, let me ask this, is the defense putting up a fight in order to keep certain evidence in regards to the testimony that the prosecution wants to submit to send Ronny Walker, sentence him to death? What are your thoughts? Do you think that Ronny should be sentenced to death, or should he have life in prison? You know, it's 12 people that's going to decide this, right? I don't know. Like, yeah, I agree, Benny. Yeah, she doing exactly what defense supposed to do. Babble, 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 right? I tell you, I just wonder what kind of witnesses they're going to put on. I heard they were expected to see about 10 of them for the defense side. And I'm pretty sure they're going to have the family speak from the prosecution side. And that's probably going to be very emotional, because remember, there was a young life lost in this, right? For no reason. Like, I have no clue if he just thought that she was a runaway, I have heard reports that they were dealing with each other and he accused her of giving him an STD and that's why he did it. But I mean, like, this is so not justified. Like, no murder is justified, right? Except for if he gets convicted of capital murder and they decide to sentence him to death, then that's justified. But for you to do this to a 14-year-old and just leave, like, really? I think that I don't know if he thought that he was gonna get away with it and get it all put on Quincy. You know, maybe that's what he thought, that he was gonna get away with this and just put it on Quincy. But I guess he got another thing coming because that is not how it's gonna work. So yeah, I definitely, yeah, absolutely. Yeah, because remember, this same guy right here that we are currently, the jury is about to currently determine if he should live or die. He was in jail before for a murder. Now, why was he back on the streets? So, right, like the rehabilitation process definitely didn't work for him. That's what I can say. So, yeah, I totally agree. Like you done had your chance, and many people don't get second chances. Like he was offered a second chance and it didn't do anything good, not a productive member of society. You cannot be rehabilitated. Absolutely no, no way, no how. Yeah, I hear them. They probably they still in the courtroom, just so y'all know. So they still in the courtroom. I'll pull it up. Oh, wait, y'all can kind of see the movement that's going on in the courtroom. So they're still in the courtroom. You know, so yeah, so prior bad acts, Benny, they didn't allow in. Just so he can be judged on currently what he's being judged on. And I think that, it's so funny that they do that in court proceedings because when you get a witness up there, remember we heard the one guy was convicted of 121 felonies. And the other guy was convicted of like 71. Like, I'm like, but they'll allow that testimony to come in regards to witnesses who have records or committed felonies, but they don't do the prior bad acts for the defendants. And, like they want to present it like it's, something, totally, I guess, fresh. So they don't, hey, if he was convicted of murder before, we're going to automatically convict him now. Yeah, but good question. Right. Yeah, they do that a lot in these trials. So like it's called prior bad acts. So you're absolutely in regards to that. So do you think that the verdict, once the jury gets it, do you think that it's going to be a quick verdict in regards to if he lives or dies? I have to laugh at you, Benny. I know. I know. Look, let her do her job. We gonna let her do her job, right? Because I think in our right, I agree. I think it's gonna come back pretty quick because either people are gonna be for him being put to death, or they're not. I don't. Most of them should probably have some idea because remember when they were assigned to the jury and were selected for the jury, they were notified that, hey, if he is convicted, you will need to stay for the death penalty phase of the trial. And, are you okay with it? I'm pretty sure that was one of their voir dire questions to kind of get their jury selection. So definitely, yeah, yeah, they definitely know that once they convicted him of this, that this was going to be part of their jury duty. And he does have a case that we found that was severed. So he has another case kind of related to this case, but they severed it that he has to go on trial for. But like what I don't understand, like even if the jury comes back and they say, hey, he is guilty, they already came back and said he was guilty. So let me restate that. They came back and already said that he's guilty, right? So if they come back today and say, hey, we are giving him the death penalty, right? Why do we need to go through another trial for a severed case if this man has already been sentenced to death? Like, I don't know. Is that wasting money or taxpayers' money? Like, what are we doing here? Like, you can't sentence a person to death twice, can you? So I think, like, if he's sentenced to death by this jury, like, why are we in need for this other case, this other trial to go through for the severed case? I don't know. Let me know your thoughts in regards to that, because I don't understand the point at that point in time. Like some people, when they get convicted of a crime, they like sentence them to, I didn't see people get sentenced like 162 years. Like, okay, you made your point with the first 40. Right, Biddy. Like you made your point. Like, let's stop wasting up everybody's time and wasting everybody's money and taking families through the heartache over and over and over again. I don't know. And I'm hoping that they save these taxpayers some money, right? Because there's definitely no reason to try have another trial for a severed case if he's going to be sentenced to death. Maybe they want to ensure, just in case something happens on appeal with this case, if he's successful with an appeal or something, that they have another conviction or another case that's separated. And that's why they do that. But it looks like they are bringing him back into the courtroom. Y'all noticed that he changed his clothes, right? Because before he was in an orange jumpsuit. So I guess they done dressed him back up. Now, I don't know why he got to get dressed back up, because the jury already know they convicted him and he is in jail. But they dressed him up. Look at him. And I'm sure that during this process, we're not going to get no remorse or nothing from him, or any kind of statement regarding how he sorry or anything, or apologize to the family. Because remember, he's still saying he didn't do it and Robert Quincy did it. Wow, Benny, 4 times? I've never been on one. They have sent me a notification, and each time they sent me a notification, I have something else going on. So unfortunately, I wasn't able, and it was just, I think I was with child with both of them, with my kids, and I was like, oh gosh, I can't go. And so unfortunately, I have never been on, but I would love to experience. They probably wouldn't pick me. I probably wouldn't make it past the questionnaire. In all honesty, they'd be like, "Oh no, she's too opinionated." I'm like, "Oh no, 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 no." Like, I'm convicting people before I even walk in. Like, "Oh no, 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 no." I can't separate it. Nothing. No, no remorse. I definitely don't think that's gonna come out. No sympathy. I don't think he's, because remember, He's stating somebody else did it. So I guess, if he wants to continue this further with any type of things that they can even actually get appeals on, he can't go up there now talking about he didn't do anything. Not that he didn't do anything, that he did something and he's remorseful. But I guess he actually could. Like, he could say he's sorry that this happened to her, but he is not the person that did it. He can say something to the effect that, he shouldn't have had Robert Creed in the car, and he committed this heinous crime. And so I guess he could compose something to support, to provide remorse to the family and not. Okay, we back in session, y'all. I'm gonna be quiet.
I didn't get that. Could you try again?
You good down there? All right, back on the lower way. That's that.
Oh, I hope he turns on the mic, guys. Hey, guy, we can't hear you. Judge, turn on your mic. Courtroom reporter, turn on your mic, please. Benny, let's start practicing our lip reading. Oh, gosh. Like, we had all that noise before. Wait a minute. Yeah, and it's not here. The sound, they don't have the sound in the courtroom. Let me see. Let me see what I could do here. Give me 1 second, guys. I'm just trying to see if I can get. Oh gosh. Okay. So I had.
I was looking at one of your graphs, but.
So I have some TiVo time on this one.
Yeah, that's right.
So I am going to fast forward us to the parts where we can actually hear. So if it sounds like it's like we move past some stuff, we actually are moving past some stuff because we can't hear anything. So I'm taking us forward in time where we can actually hear what's going on.
It doesn't talk about the effect.
Okay, here we go, guys.
Her death. But the fact that it alludes to the fact that that no longer applies would show an effect on the community. So I think this letter's fine in its entirety.
Thank you, Judge. The next one, and very minor, Leslie Alexander, that is the grandmother of Alexia. The court has already ruled about the New York trip, so for the record on her letter, Lexi always talked about going to New York. We were planning to surprise her with the trip for her 15th birthday. Sadly, we never had the chance. The court has already ruled that that is okay for Miss Alexander. However, sadly, we never had a chance. Does not go to the uniqueness of Miss Alexander or the loss to the community. So, based on the ruling, I'm still objecting to the line concerning the trip. However, I understand the court's ruling, but certainly, sadly, we never had the chance. I am objecting to it. So, Your Honor, and that's it for that one. Have you heard that?
Yes, absolutely.
I would cite to Jordan v. State 176, 7th, 3rd, 920. It's a Florida Supreme Court case out of 2025. It indicates evidence concerning the impact of the victim's death on the family members is relevant for the impact. So this is the effect it had on the family.
It's another family member. I mean, it's analogous, but it's a different family member. So I'm going to allow that as well. Now, the question, what about the line, sadly, we never had the chance?
That's the impact it had on the family. This is the victim's grandmother.
I agree. I agree with that as well. Just want to hear what you had to say. It's almost the same, but it's her effect on her. Okay.
And the principal,
Delia Gadsden
Delia.
Yarborough, is that right?
Delia Gadsden Yarborough.
Delia.
Yeah.
But again, overall, this statement is comports with the statute as well. I'm just consulting with co-counsel. Judge, I was looking at one of the paragraphs, but we don't have any objection to that letter.
All right. Very good. Okay. Next on the agenda.
Okay.
And Ms. Fawcett, you may have these back. Thank you.
thank you.
Okay. All right, we have a motion to exclude one of Mr. Terry's witnesses by the name of Raymond Lee. Raymond Lee was present during the prior violent felony incident in October of 2003. That's October 23rd of 2003.
Okay.
We are moving to exclude him, and if he's not excluded, we're going to have to take his death oath for these reasons. Former Detective Drabenek and Mr. Lee were originally listed in this case as witnesses because I filed motions demanding to know, of course, what the PDF was and who the witnesses were and got documentation appropriately from Mr. Terry. But then Detective Drabenek had changed to Detective Masushi. However, they didn't know where Mr. Lee was. And in fact, unfortunately, Mr. Terry only had Mr. Lee show up like about 2 weeks ago at jury selection. So he was nowhere to be found. I deposed Detective Masushi because he was going to be the only witness. There's a very long history behind this prior violent felony, and it can get very messy. We're talking hung juries, conviction that got reversed. This should be limited to the pleas that he entered in 2010. There's also a lot of issues with the identification. The appellate court ruling scathing on the weakness of the case and the ID that was done because Mr. Lee had done his own research.
Okay, let me see. You said so you can't hear anything? Wow. Okay, well, let me check this and see. Give me a second. Let me try.
Me and Ms. Dunker was there after we deposed Detective Sushi. I'm not using any witness. This is months.
Oh, it's not you. I appreciate you. Let me know. Let me go in. I'm gonna start. I'm gonna stop and I'm gonna go back in. I'm not gonna stop the stream, but I'm gonna stop the feed and I'm gonna go back in. Let me go out and go back in. Give me 1 second here. Yeah, because I can hear it perfectly fine, but yeah, which is like you can hear me, but you can't hear them. Like you don't want to hear me, right? Every now and again, you want to hear me. Give me 1 second. I'm gonna go back and get it back up. Give me a second. Okay, give me a second. I'm gonna remove this one. I opened up a new window. Um, so we can. Thanks, Benny. I'm glad that you want to hear me. But we want to hear them. I know I want to hear this too. Show. Okay, let's try this.
Would show an effect on the community. So I think this letter's fine in its entirety.
Thank you, Judge. The next one, and very minor, Leslie Alexander, that was the grandmother of Alexia. The court has already ruled about the New York trip, so for the record on her letter, Lexi always talked about going to New York. We were planning to surprise her with the trip for her 15th birthday. Sadly, we never had the chance. The court has already ruled that that is okay for Miss Alexander. However, sadly, we never had the chance. There's not going to be Miss Alexander lost to the community. So based on the ruling, I'm still objecting to the line concerning the trip. However, I understand the court's ruling, but certainly sadly, we never had the chance. I am objecting to. So, Your Honor, and that's it for that one.
Yes, absolutely.
I would cite to Jordan.
Oh my gosh, I don't know what that's about. Let's see. Nope, it's the same. Okay, because I can hear it on my end, but you can't hear it on your end. Okay, let me see what I could possibly do here. Let me stop sharing. Okay. I know where's a super tech team when you need them. Anything now? Did y'all hear that? Let me see. Is anybody else having any audio issues? Yeah, because I can hear it on my end now. Just so y'all know, we won't miss anything because I'll rewind it once we get everything together. But let me see. Let's see here. Oh, wow. Yes, I think that y'all, it's not the volume, I can hear it on my end, but you guys can't hear it on your end. Let me see here. I may have to start another feed. Um, Unfortunately. Let's see here. Let me see. Present, share screen, share. I'm gonna try one more thing, guys. Also share audio, okay.
Judge, I was looking at one of the paragraphs, but we don't have any objections to that.
All right, very good. Okay. Next on the agenda. And then, Ms. Fawcett, you may have these back. Thank you.
Okay. All right, we have a motion to exclude one of Mr. Terry's witnesses by the name of Raymond Lee. Raymond Lee was present during the prior violent felony incident in October of 2003. That's October 23rd of 2003.
Okay.
We are moving to exclude him, and if he's not excluded, we're going to have to take his depo for these reasons. Former Detective Dravenik and Mr. Lee were originally listed in this case as witnesses because I filed motions demanding to know, of course, what the PDF was and who the witnesses were and got documentation appropriately from Mr. Terry. But then Detective Dravenik had changed to Detective Masushi. However, they didn't know where Mr. Lee was. And in fact, unfortunately, Mr. Terry only had Mr. Lee show up like about 2 weeks ago at jury selection. So he was nowhere to be found. I deposed Detective Masushi because he was going to be the only witness. There's a very long history behind this prior violent felony, and it can get very messy. We're talking hung juries, conviction that got reversed. This should be limited to the pleas that he entered in 2010. There's also a lot of issues with the identification. The appellate court ruling is very scathing on the weakness of the case and the ID that was done because Mr. Lee had done his own research with a potential hearsay name, found a picture, doesn't look at a photo pack till after he has a picture. It's a mess. So Mr. Terry specifically told me, and Ms. Dunker was there after we deposed Detective Masushi, I'm not using any witness. This is just too messy. I'm only going to use the certified judgment and sentence. And that was probably about 2 months ago, something like that, maybe a month and a half. And it remained that way until a witness. I said, well, we have not, you said you were not calling me, you're using the certified, we have put that aside. Either way, we would have to do something with those who are summoned to call him. Then it's like, no, I'm not going to call him then now. I'm going to call Detective Masushi, who we've already deposed. I'm like, okay, now it's Masushi. But that's okay, Detective Masushi's not here. He's in Yellowstone. So then it became Detective Dravenik. And Detective Dravenik is here to testify, and we got a chance to speak with him, and I got his report. I was specifically told last night, and I have the text, they are not calling Raymond Lee. That it is just going to be Dravenik, which I don't have an issue with. Now this morning, I'm told they're using him. So Your Honor, we have not fully prepared them at this point for Raymond Lee. This became an issue to us.
Where is Raymond Lee right now?
He's here.
Okay. Well, we're going to be taking a break for depositions this afternoon, so I can assume you'll get him done. And then,
The only, and that's fine, and I don't have a problem with that. Just if I can respond to a couple of points on that. And most of what Ms. Summer said is accurate as far as, the
Okay.
conversations we've had. However, my feelings have changed for a number of reasons. Number one, when I saw her motion basically trying to eliminate 2 of our aggravators, I realized that I may be stuck with just 1 aggravator, and all I've got is certified copies of conviction. So around that time, when I saw that motion, not knowing what your course.
I don't need to know your reason. It's okay.
Well, yeah, Judge, the fact of the matter is, we did not know or have contact with Brandon Lee until he showed up for the trial. And so at that point in time, he seemed to indicate to me he wanted to be a part of this. So I let Ms. Schlemmer know, and so that was kind of where we were going to be with this. Then when I called him to tell him, hey, you need to come down for a depo, we need to get this, he's like, I changed my mind, I don't want to be involved. At that point in time, I said, you have a couple of hours to think about it, but please, you need to know. He never called me back. I tried to reach him most of the day yesterday, he didn't call. That's when I sent the text to Ms. Schlemmer saying, he's not responding, we're not going to call. After I left work yesterday evening, Ms. Fawcett apparently was able to reach him, and he did agree to come down for Ms. Fawcett.
Okay.
I was told that this morning.
I
He's
understand.
here. The only problem with doing this deposition later is that we don't have that much to present in our case. Our case is very short. Literally, right now, it's going to be Detective Dravenak, our certs.
Well, you do them over lunchtime then, because we're not going to bring these people in just to say, hey, thanks for coming back. See you in an hour and a half.
I understand. That's
So,
fine, Judge. We can.
I would do them over
We'll
lunch.
do what we can before. Can we do the victim impact slightly out of order then, Judge? Well, we've already.
Your order is your order. I'm not going to complain.
Well, just based on the case law, we wanted to know if there was any objection.
Oh, I understand that. Yeah, you got to follow that part of it.
The case law suggests that victim impact statement must be brought after a aggravator has been proven. But if they're not going to, the CCP is going through the facts, so I think we're okay on that. So,
Okay.
all right, that's fine. So I think there's enough we can do today before lunch. We should be fine.
So, Your Honor, I'm not taking away my objection, obviously, this is.
I understand that.
Phase, and
I
now
know
we're
that.
gonna be in question.
I appreciate that.
So, thank you. Did you want to address really quickly the photographs that they have for victim impact? And there's also photographs.
That just came in this morning, right?
Yes,
You might as well take care of that.
yeah, might as well. Ms. Fawcett, you guys have changed it to show this to the judge? Yes. We have photographs of Alexia Alexander and photographs of Elaine Caldwell.
Okay.
Would you like me to go first, Your Honor?
Yeah, let me look at it. You plan on introducing both packets, correct? Victims is the first victim. I'm just not sure if it says no. We can't make this a feature. Then this packet, this should be our current victim. All right. Okay. Regarding the victim in the first case, what is your opinion on those?
Yes, Judge, we are objecting to those. As we all know, the Supreme Court is quite clear that we cannot make the prior violent felony the feature of the case. We are already calling the lead detective. We are already potentially calling Raymond Lee The Duncan case that I sent to the court, in that case, they talk about like gruesome photos, but they're talking about the use of photos and how they already have the detective. We're making it a feature of the case with autopsy photos. We're not actually getting, as far as I know, I mean, she was shot one time. I don't think any medical examiner is being presented to say it would assist or aid them in any way. So based on Duncan, and the fact that it makes it more the feature of the case, and we already have testimony, we are objecting to any photographs of Elaine Caldwell. If in fact the court was going to allow a photo, which I would still object to, we certainly are objecting to the autopsy photos. There is one of her, if the court, but I'm not giving away my objection, just saying if the court wants to consider that.
State, just response to the first crime victim.
So, Your Honor, the state would cite to Wyatt v. State. It's found at 641 Southern 2nd 355. It's a Florida Supreme Court case from 1994. So the Florida Supreme Court has previously indicated that photos of the other victim may be admissible. So this is another victim. We're trying to show the injury to this particular victim. The lead detective is present to testify, and he also attended the autopsy. Why is this relevant? Because this is another female victim who was shot in the head, and the victim in this case, Alexia Alexander, was shot in the head. It is not that the court is indicating that the prior victim's photographs are inadmissible. It's to the contrary. The Florida Supreme Court indicates that it is appropriate for the jury to see photographs of the prior victim. The Duncan case that the state has cited does not stand for the notion that that photographs of the prior victim are inadmissible. In fact, in the case cited by the defense, it says the defendant murdered his fiancée with a kitchen knife, and they talked about that. The defendant in that case argued that the trial court committed reversible error in admitting extremely gruesome photos that were depicting gaping wounds to the prior victim's head and face. The photographs related to the defendant's 1969 conviction of second-degree murder. Although the Supreme Court did agree that the prejudicial effect of the gruesome photographs outweighed its probative value, the error was harmless beyond a reasonable doubt. Once admitted, no further references were made to the photographs. Moreover, the jury was well aware of the fact that the defendant had previously been convicted of a brutal attack. We are establishing that the defendant was in fact convicted of a brutal murder, that in fact the murder was a shooting, that in fact this is that prior victim. The photographs that have been provided to the court depict that particular injury. The detective went to the autopsy.
I understand.
And I just selected very few photographs that were not overly gruesome in any way.
Judge, I cited Duncan v. State just for the record. The court has it, so does the state 619, 7nd, 279. Of course, we know it's within the court's discretion. There's no bright line rule that photographs admissible, sure, but it's also an issue of 9403, as Ms. Bassetti had mentioned, that this is going to become the feature of this case. I mean, we're calling already Raymond Lee, we're calling Detective Dravenik. It's the probative value is outweighed by the prejudice, and it's going to make this the feature of the case, and the Florida Supreme Court is clear that cannot occur.
The state has to be able to prove its aggravating factors, and one of the aggravating factors in this case is the prior violent felony, which is this and happened.
I understand what you need to prove. Stand by. All right.
And one more comment on this, Judge. The aggravator is the conviction. The conviction was a plea to this case. That is another factor why we don't need to be going into.
It's
all
clear though the
aspects.
pictures are allowed. I understand your argument and your objection. So regarding the first victim, I've chosen two photos that I'm going to allow. And I will give them back to the state. It's going to be, you guys want to approach?
Hey, Benny, no talking right. No, they're not talking. It's just kind of whispers right now. Can you hear me okay? Yeah, it's just kind of like soft whispers, like they're not doing anything right now. Yeah. Look, and I was scared to kind of come in on the microphone because I know you said it. I sometimes it's like blaring in your ears, so I didn't want to just pop in and start talking. But yeah, they're just kind of like whispering. I'm assuming that they're just going over some things that they're trying to put into present to the jury for his death penalty case. So I was hoping that it wasn't going to be a long sidebar or discussion, but it appears that it is. So, guys, what do you think? Should he be put to death? I know they're currently fighting over should his prior bad acts be presented to the jury, and I think they should be. I know they didn't present it in trial, but for anybody that's just joining us or just watch for the first time, and I mean, Ronnie was convicted of a murder before and was in prison and for manslaughter, and he got out, and now we have a young life that has been taken at his hands where he has shot and killed 14-year-old Nylexia Alexander. So I think at this point in time, yeah, his prior act should be brought in. I know, Benny. I gotta keep you woke. I gotta keep you up. So I'll try to come in on my microphone, not too hot. I'll tone it down and come in softly, and then I'll start blaring. Yeah, I agree. Yeah, Benny, the prior should come in anytime, girl. Yeah, look at him. Like, wow. I guess there is nothing for him to be nervous about at this point in time. He made his bed, so now he got a lot in it, right? Yeah, I know that the defense, they wanted to have their witnesses speak by Zoom, and the judge was like, I don't allow Zoom in my courtroom. You know, and I was thinking to myself, I said, what court doesn't allow Zoom in 2025?
Preliminary instructions to the court earlier this week. I see Mr. Terry sent some yesterday. I sent the preliminary instructions. I believe they are standard. I didn't make any changes. I do apply in this case, which is going to be your instructions from 2018.
Correct. Any disagreement?
The instructions, I thought I provided standard instructions.
Well, you guys each have given me some. If you want to go over that during the lunch break and see if there's any,
We're going to read them now.
oh, you want to go through them right now? Or you want to do the charge conference now? Oh, yeah, you're talking about just the preliminary instructions.
Yes.
Yeah, let me look, because there's two different sets.
The state took it directly from the statute book, which I believe is.
The 2018 statute book,
What's that?
the old statute book, right?
I'm not sure. I probably took it from the. I didn't.
Let me find-
I do have a copy. I can show it to Mr. Terry. Preliminary
Can help me
instructions.
sort through this.
I'm trying to find that.
I got it out of the way.
No, I recognize that. Judge, I have no objection to the defense's preliminary instructions. I didn't realize that the ones I was getting was from today's. They've changed quite significantly.
Yes.
So I didn't realize I was putting today's, and it should be, she is correct, it should be 2022's, I believe should be.
Just, it's 3 pages, correct?
Yes.
And Judge, if you can just kind of let the jury know that the delay is no fault of the state or the defense.
Oh.
Okay. Don't want them to be mad at us.
You don't have the copy I sent?
I have.
Okay.
What I'm saying is, logistically, bring them in, you want me to read these and dismiss them for lunch? Or you just wanted to dismiss them for lunch and you started with that?
We can probably get openings in there, I believe. My opening's not
Okay.
super long. I don't think either of our
We'll do
openings.
that. So, preliminary instructions, openings, lunch break. Very good.
Got it. Thank you, Judge.
What time?
Are you gonna tell them it's gonna be a short day today?
I will. I'll let them know it's a short date and that the delays have been my need for information and the attorneys are not to blame. I'll also ask them.
Yeah, Benny, they're not really talking into the microphones right now. They're kind of standing up. I believe they're about to bring the jury in from what it appears in the courtroom. So they're not really saying anything at this point in time. I'll check back with you as soon as I hear something. Yeah, they better have it up in regards to us hearing when they're trying to present to the jury. But we'll definitely keep an eye out on it. I'll let you know as soon as I hear it come through my headset. That way you can know. You hear that? The all rise? Okay, they bringing the jury in. So you should be able to hear Benny because they're going to talk into their microphones because the security guard said, all rise for the jurors.
Y'all may be seated. Thank you, ladies and gentlemen. All right. First off, were you all able to follow the court's instructions? No issues? Nobody had any contact with any media stories, print, radio, TV, YouTube, none of that? And no one spoke to you about the case, and you never spoke to anyone about this case? All right, very good. Also, a couple of things just logistically. We're going to be breaking around 2 o'clock this afternoon. So you'll have an early day today. The state and the defense don't anticipate that this is going to be a lengthy process overall. So that's so we can do some extra work in the afternoon. The attorneys are still going to be working hard. And also the delay today was because of me. I had them in here at 8:30 this morning. And we have been working right up until the very second we went and got you. So if you want to be mad at someone, it's all on me, but they have to listen to what I say apparently. And after that, I think we're ready to go. So, ladies and gentlemen, members of the jury, you have found the defendant guilty of one count of murder in the first degree. This punishment for this crime is either life imprisonment without the possibility of parole or death. Before proceeding further, it will be helpful if you understand how the proceedings will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have given their opportunity to present their opening statements, the state and the defense may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence you have heard during the guilt phase of the trial, is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proved beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, and 3, whether mitigating circumstances are proven by greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence, and after argument of counsel, you'll be instructed on the law that guides your deliberations. Aggravating factors. An aggravating factor is a standard to guide the jury in making the choice between the verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of the crime or the harm to the victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in proving your verdict as to the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death. Let me start that. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, you do not move on to consider the mitigating circumstances. Mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to decide whether the aggravating factors that you unanimously find to be proven beyond a reasonable doubt outweigh the mitigating circumstances that have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence more likely than not tends to prove the existence of the mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Once the state has presented evidence of an existing aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate Alexia Alexander's uniqueness as an individual and a loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. State, you may proceed.
Thank you, Your Honor. Ladies and gentlemen, Alexia Alexander is not the first person Ronny Walker has killed. See, back in October of 2003, a woman by the name of Elaine Caldwell was shot in the head. Her home was broken into, a robbery was taking place, and ultimately, that man seated right there, Ronny Walker, was convicted of her murder. That, ladies and gentlemen, is an aggravator, and one of the two the state will prove beyond a reasonable doubt, and which makes Ronny Walker death eligible. We are now at the stage where guilt is not an issue. You have already found the defendant guilty of the crimes he was charged with, and so now we are at the stage which is called the penalty phase. The issue now is your determination of whether the sentence should be life in prison without parole or death. The state will be presenting two aggravating factors. One of the aggravating factors, and I'm going to get into in a minute, that you've already really kind of heard of and heard through the evidence, because here you can still consider all the evidence that was presented in the case, in the guilt phase. Okay, so one of the aggravating factors is an aggravating factor called cold, calculated, and premeditated. And you're going to learn what exactly that is and what the state has to prove. The other aggravating factor that the state has claimed in this case is a prior violent felony conviction. And that is the death of Elaine Caldwell at that man's hands. Now, although you probably don't need any reminding of the process that both Ms. Fawcett and Ms. Schlemmer covered so thoroughly during the voir dire, the state must prove at least one of those aggravating factors beyond a reasonable doubt before you can even consider death. And I think you've heard that even in the judge's preliminary instruction. And we have no doubt that you will find both aggravating factors have been proven beyond a reasonable doubt, but you need at least one of those aggravating factors proven beyond a reasonable doubt by the state before you can then consider death. And again, everything that was presented and argued in the guilt phase can be considered by you when considering certain aggravating factors. And in this case, that is the cold, calculated, premeditated. So the state is not going to come and have to represent all of those witnesses and all of that evidence. I think you all would go crazy. No, you can consider all of that. It is considered part of this trial as well. So let me talk to you a little bit about cold, calculated, and premeditated. And obviously this is a aggravator where there is a heightened premeditation in it's calculated and it's done in a very cold manner. So in this particular case, you heard evidence from Robert Quincy Creed that he was searching for her, clearly had a plan in mind.
Judge, may I read?
Yes.
And again, we're not going to represent all this. I'm just showing or explaining to you some of the things that you heard that may apply. But the fact that he was searching for her, that he got her in the car, bought her a drink, and took her, most importantly, to this location in the middle of the night, a dark location, according to Quincy Creed, a location where he pulled up so that the car was easily accessible on the driver's side to that vacant lot where her body could be left. All shows, ladies and gentlemen, heightened premeditation. And all of that is evidence you already have and evidence that you can consider when determining whether or not it was cold, calculated, and premeditated. And then you heard from Quincy Creed she was shot in the car. And as I described to you earlier, the evidence we believe showed that she walked out of that car and that Ronny Walker confronted her in that vacant lot and shot her 3 times in the head. That is basically an execution style killing.
Objection, Your Honor, improper argument. And same arguments made at the bench.
Yeah, I'll sustain.
So you can consider how she was shot in determining whether or not this was a cold, calculated, and premeditated kind of case. All of that the state believes will add up to cold, calculated, and premeditated. That is one of the aggravators. And again, you're not going to hear a bunch of evidence. That's why this is going to be a much shorter presentation for you all. We're not going to go back through all that. We're going to rely on your memories of all of that and informing a decision as to whether or not that aggravator applies. The second aggravator, however, is one you have not heard or learned about until today. So we do intend to present some evidence. It's still going to be very short and it's not going to be as significant. We're not going to relitigate that case. We're not going to do all that, but we are going to present a couple of witnesses, or at least one witness, to tell you sort of what happened there. Give you a little bit of the facts surrounding what occurred so you can kind of understand about the prior violent felony. And you're going to hear about Elaine Caldwell, and you're going to hear how this was her home that she was in when Ronny Walker came in there. You're going to hear about the fact that this was a robbery, and that because of them breaking into the home, it was a burglary. That there was another accomplice with that individual. You're going to hear that she was shot in her bedroom and shot in the head and killed. You will see certified copies of convictions that indicate Ronny Walker was convicted of those crimes. You'll hear from the lead detective at the beginning of the investigation, who will describe to you the scene. And he will also tell you he attended the autopsy and describe to you the injury that Elaine Caldwell suffered. All of that will be brought to you. Again, in a more truncated fashion, but a way for you to understand what happened in that prior violent felony conviction. Those two aggravating factors will be proven to you beyond a reasonable doubt. And at that point in time, you can consider whether to sentence Ronny Walker to death or life in prison. You will then decide whether each aggravating factor can sustain a sentence of death. And I submit that you will most likely hear mitigation for Ronny Walker. And you will need to consider all the mitigation the defense provides and give it whatever weight you feel it's appropriate. Then you will weigh the aggravating factors that the state believes it will prove to you beyond a reasonable doubt against those mitigating circumstances that you will hear about. And again, you give each the weight you feel they deserve. And then if you find that the aggravating factors outweigh those mitigating circumstances, and again, this must be unanimous at this point, then you go to the ultimate decision, and that is whether or not the defendant should be sentenced to death. We are confident, ladies and gentlemen, that we will have proven our aggravating factors, that you will give them great weight because they deserve great weight, and that you will find these aggravating factors outweigh the mitigating circumstances you're going to hear, and that the appropriate sentence in this case is the sentence of death.
Thank you, Jeff. May I please support the council's? Good morning. My name, you haven't heard much about me since jury selection. My name is Carolyn Schlemmer again. I talked with you all quite a bit about your feelings about the death penalty. Ladies and gentlemen of the jury, we want to thank you. We want to thank you for the service you have done in this case. It has been over 2 weeks that you have been with us. The time and attention you have given to all of us, including Mr. Walker. We want you to know that we fully accept your verdict. Fully accept your verdict. With your verdict, you have assured that Ronny Walker is punished. You have assured with your verdict that he will die in Florida State Prison. He will never be released and he will be punished. You have assured that. The decision you now have to make is, at whose hands does he die in Florida State Prison for what he did to Alexia Alexander? Because life without the possibility of parole, as you remember from jury selection and Mr. Terry talking with you, Life without the possibility of parole or the death penalty are the only choices. And you are assured that Mr. Walker will never walk free. No matter what, Mr. Ronny Walker will die between the cement walls of Florida State Prison. Now, this is our opportunity, and I want to make it clear as well. We are not trying to excuse what was done to Nylexia Alexander. You will hear from Nylexia Alexander's mother and her grandmother. We anticipate Mr. Terry will present them. Ashley Alexander is a wonderful woman. You will hear that's a good family. So we are not in any way, shape, or form going to present mitigating circumstances to you to try to excuse Mr. Walker's behavior. But we have to give you that information, and the law recognizes that information, mitigating circumstances. Not an excuse. Maybe an explanation, maybe explaining, and being given to you so you can make that crucial decision, that individual moral decision we talked about during jury selection. And I agree with Mr. Terry when he summarized the law. There's many steps you will need to go through when it is time to go back and deliberate Mr. Walker's fate of how and at whose hands he will die. You have to find an aggravator unanimously beyond a reasonable doubt. That makes him then eligible, exactly as Mr. Terry indicated. You then have to find that those aggravating factors are sufficient for the death penalty. You then look at mitigating circumstances. You then look at whether the aggravating factors outweigh the mitigating circumstances. And as Mr. Terry said, once you have gone through all of those steps, you're going to make that crucial decision. And you'll hear more later on. The judge will be giving you more about the law before you go to deliberate. Remember, just keep in mind, as we talked about during jury selection, that even if you find that final step, that those aggravating factors outweigh the mitigating circumstances, you can still, no matter what, vote life without the possibility of parole. And that is what we are going to be asking you to do. I want to tell you a little bit about Ronny Walker. Ronny's not perfect, certainly. You've heard the case. No one is standing up here saying that, but you've got to make a critical decision now. But some of the things you will hear, we want to tell you about. January 22nd, 1978, Ronny Walker was born. At the time of Nylexia Alexander's death, he was 44 years of age. He is now at the age of 47 in his life. Ronny has 5 siblings. He's one of 6. He has cousins. He has his mother. You will hear of some happy times that Ronny had in close-knit family. But Ronny Walker is a product of his environment. You will hear from his mother, Emma Hamilton. Emma will talk to you about Ronny's life as a child. You will hear that she raised Ronny and his siblings as a single parent. She'll talk to you about that. Up until about the age of 10. Ronny was with his siblings until about that time. You will also hear that because Miss Hamilton is a single parent, his father was never in the picture. In fact, Ronny doesn't know his father. He was never a part of Ronny's life. His name is Larry Walker. He took off on Emma and left her with the 6 children, 3 girls and 3 boys, one of which is Ronny. She will tell you Ronny was quite sick as a child. Ronny suffers from seizures. Seizures that Miss Hamilton will describe to you that happen, and sometimes multiple seizures in a day. He had been hospitalized at 6 months of age for double pneumonia and bronchitis. And after that point, so about 6 months of age, the seizures started and continue to this day. But these seizures would result in head injuries. And Ms. Hamilton will explain to you a seizure even caused him to fall out a window and drop 2 stories and hit his head. You heard in the jail calls that you heard during the guilt phase, you might have heard a stutter. She will talk to you, and other family members will, about his speech being delayed and the stuttering that he speaks at certain times. Now, we're about at 10 years of age. Ronnie's growing up with his siblings. But at 10 years of age, Emma Hamilton will tell you she lost custody, gave up custody of her children to her sister, who is now deceased, Gloria Hamilton. And the children were sent in all different directions. The family was broken up. Ronnie is 10. Ronnie and his brothers, John and Antoine, nobody knows today where John is, and Antoine is now in prison. Ronnie and his brothers stayed with Gloria and were raised by Gloria. His sister Paulette was sent off to live with her father. And his sister Tangi was sent to live with her father. So at 10 years of age, his family was separated and torn apart. So we have no father, and now we have no siblings. You will hear that Gloria moved frequently. Ronnie changed schools frequently because of that. He never graduated high school, never got a GED. You will hear Gloria did not live in safe neighborhoods. All the neighborhoods she lived in had drug dealing and violence. Emma Hamilton, after she lost Ronnie and all of his siblings to Gloria in the custody of her, Emma then spiraled into drugs and alcohol. And Emma will be honest and tell you that she has an addiction that started about that time, and she is as well. She is mentally ill. Gloria moved around a lot. Ronnie had to change schools, and when Gloria moved around with the children she did have, including Ronnie, it was not moving to good areas. It was a bad area to another bad area. School issues started for Ronnie. Emma will tell you about the 10 years of age. The seizures will continue. You will hear that. Now, you will also hear that Ronnie eventually had 3 children of his own. Ronell, his son, Ron J., a son, and a daughter named Paris. In 2021, Ronell, this is about approximately a year before the tragic death of Nylexia Alexander, that Ronell was murdered, wounded by gunfire, and was killed. You will hear how that affected Ronnie. About that same time in 2021, Ronnie's grandmother, her name is also Emma Hamilton, Emma's mom, also died, right about 2021. I don't think Emma's going to be able to give you an exact date, but it's right about a year before the tragic death of Nylexia. You will hear how they were close. You will hear as well from one of his reunited sisters. And she'll tell you a little bit about how she doesn't even know what her real name is, but her name is Tangi, or Tanya Hamilton. Now, she was sent at about the age of 10, when Ronnie went with Gloria and his brothers. She was sent to be with her father, while Paulette, as I said, went to her father. But Tangi never was able to have a relationship with Ronnie. In fact, she had to use Ancestry.com and Ancestry sites to be able to get her family back. She will tell you that Ronnie and her were respectfully about 3 and 4 years of age at the time. They never grew up together, and now they've been able to reconnect, though. And she will tell you that she loves and supports Ronnie. Ronnie's cousin will speak with you. His name is Davis George Jr. And he's going to talk to you about the fact of the conditions living with Gloria and the bad neighborhoods and the violence. Ronnie wanted to always be at his house, Davis's house, who was close to Ronnie growing up. He was close to his family members growing up. He will tell you how Ronnie basically lived on the wrong side of the tracks after being taken from his mother and given to Gloria, where Davis is on the other side of the tracks. A good house, lots of sports, his children are successful, and he has had a productive life. And he'll talk to you about the difference and how Mr. Walker always wanted to be over at his house when he was young. And he supports Mr. Walker. And you'll hear from other family members about the effect of Ronnie never knowing his father, the death of his son, and the death of his grandmother about a year before this, the witnessing of seizures, the family background. We're going to talk a little bit. We're going to have Emma paint the picture for you who everybody is, because you're going to hear some names, and how they support Ronnie. Please, please remember as you're listening to this evidence, again, none of this is presented as an excuse at all. It is to help you in making that crucial decision you were about to make. Mr. Terry indicated you've already heard facts about cold, calculated, and premeditated. However, that requires a heightened premeditation, and Mr. Terry acknowledges that. You have found him guilty of premeditated first-degree murder. However, this aggravator is a heightened premeditated, over and above your finding of premeditation. There has to be a careful plan, prearranged, and there must be time for substantial reflection. So it is different. Part of the instruction you will hear later is, of course, the definition of premeditation, as you have found Ronnie guilty, but it will talk to you about how it is much above that. And I will submit to you at the end of this, the facts do not indicate a careful plan. The video that you saw showing the vehicle, that's a residential neighborhood. There's street lights. Ronnie's got his street lights on. Before that, he picks up Nylexia with Robert Creed. The lights are on. It was very bright. You can look at that video again if you'd like. But he goes down Florabraska and makes a U-turn because it's a dead end, comes back up from the dead end and parks at the vacant lot. And it's approximately 47 seconds in the vehicle at the time Nylexia is killed. And the events before the car pulls away. The car only shuts off its headlights when it's parked. There's a little, when it starts to go from that lot, puts lights back on, they flicker off, then they come back on. This is a residential area. There is no evidence that you have heard at all in the first stage that he had some plan to kill her with that heightened premeditation. Certainly the premeditation you all found, and with the number of gunshots, but this is different. This is much more heightened. There was no evidence that he wanted to kill her, intended to kill her, planned it, and had a prearranged, careful design. Robert Creed said the only thing, they go out, Ronnie's trying to find a girl for Robert Creed, and then Robert Creed says he was, quote, looking for the girl. That's it. He picks her up. They go to this residential area, which Detective Whelan himself described as a residential area. So we submit to you that when you have, and you've heard all the evidence, you're pretty much not going to hear any more evidence about that, as Mr. Terry said. But when you get the jury instruction and you see the difference from your verdict already, we submit to you that they clearly will not have proven cold, calculated, and premeditated. A prearranged, heightened premeditation with a careful plan to murder. There's no evidence of that. That is an aggravator in the state of Florida. The state is seeking it. It is up to you to make that determination. And I submit it is what you have heard clearly does not rise to that level. And you'll hear the instruction the judge will give you, and we'll talk more about that later. You can also consider things from the guilt phase. His cooperation with law enforcement, his consent for a buckle, the fact he talked to them. Those are things also that you can consider. And then, of course, any mitigating circumstances presented or anything presented during the guilt phase by the state of Florida. One thing I want to tell you about his conviction. The incident occurred on October 23rd of 2003. Detective Drabenik was the original officer, original detective. Mr. Terry indicated he is in fact calling Detective Drabenik. Almost 6 years later, Detective Drabenik will tell you the case went cold. But in 2010, and so the case itself, you're going to see two different judgment and sentences that Mr. Terry is going to put into evidence. They are from the same incident, so we just want to make sure that you know that, from an incident occurring on October 23rd of 2003. But what you're going to hear, Ronny Walker pled to those charges. He pled. Please, none of this, as I said again, that we will present to you is going to be an excuse. We are empowering you for your individual moral decision. In making that decision, you will make sometime in the next few days. And remember mercy. And because the aggravating factors you can believe outweigh the mitigating circumstances, you can still give mercy. These are not shown as an excuse, but to show you that man is broken. And he is worthy of a life sentence without the possibility of parole and not the death penalty. You will not hear that this is one of the most aggravated and least mitigated cases. He's broken. He will die in Florida State Prison. And he will never get out. And that's what we are going to be asking you to do after all of the evidence and you hear the law. Select life without parole. And on behalf of everybody, I thank you. Thank you, Judge.
All right, ladies and gentlemen, we're going to go ahead and take our lunch break now, and then we can come back while we begin presenting your cases. So I remind you not to talk to anyone about the case or listen to anyone who is about the case. Remember, there's people all over. Make sure you stay away. Thank you. See you
All rise.
1:15. Excuse me, 1:45. All right? No, 1:15. Never mind. Never was good at math. Jury's left, y'all may be seated. Any matters we need to discuss before we recess?
Judge, just for the court's knowledge, like we're having a hard time getting a court order.
No, there's one in there.
You have,
There's a court order in there. I just got a message.
okay, cool, thank you.
Thomas Hall. Thank you, folks.
All right, guys, what do you think? So, is the jury going to believe the defense in regards to this trauma, PTSD? Is that enough? Like, remember, this guy, he committed murder before, and like, I didn't know that the prosecution was going to come out that strong. Like, hey, he was convicted of murder once before. Let us give you the details that we once could not give you. Right? So, as a juror, I'm just even as a spectator, right? I'm sitting up here and I'm like, that hit home really well for me. I was like, wow, they came in strong. There was no build up to let me tell you what he did. It was just boom, right in. Loved it. Perfect. I'm glad that they went right in regards to that. Like, yeah, Benny, right? They're not playing around in regards to this. And rightfully so. Like, this man murdered a 14-year-old. Like, really for no reason. Like, none. Like, it's just unexplainable. And like, he had a second chance. He had the opportunity to come out and show that he was rehabilitated. that he could be a productive member in society. But no. That's not what he wants, right? He wants to be around here messing around with 14-year-olds and finding kids on the street, because I promise you this is probably not the only one that he's dealt with at this age, right? So manipulating her, whatever the case may be, like, how dare you? How dare you? I just don't understand. So yeah, I'm so glad that they came in hard, and no matter what the defense is trying to put up, all this stuff about these stories in regards to his history and his past, I'm pretty sure they did that with the first trial, right? Right, Benny. I got you. Yeah. Like Benny says, like Mr. Terry, the prosecutor, he is definitely on top of it all, which is great. Presenting this stuff and coming out with his hammer in regards to his pre-convictions. And they're going to actually, it's like we're going to get a trial within a trial, right? Because they're going to put on a detective from the first trial and things of that nature. So we're going to get details on how heinous and how cruel the robbery that went bad that he attempted to do, where a lady was shot, and like, really? So he had his second chance, and unfortunately he decided that he didn't want to take his second chance, and he just wanted to get out here on the streets and hurt someone else and murder someone else. And then he pulled Mr. Robert, Creed in it, Mr. Quincy, right? So he pulls him in it and tries to blame him on it, knowing that his situation, he doesn't have anywhere to live. He doesn't have a job. He's going between houses. So he goes and wakes him up and say, hey, come ride with me. I'm going to hook you up with some girl. Although Mr. Robert Quincy was, feeling ill, he got on up and went with his friend. And this happens, right? Like, and then he threatens his life and tell him, you better not say nothing. Right? Or I'm going to kill you or unalive you. Like, really? Wow. Like, it's amazing to me. So I'm, as with the jury convicting him, what I done figured out, and I don't know if y'all done caught on to it, like, he really did go tell Stanley Wilson, hey, I may need you to bail out Mr. Robert Quincy, right? Miss Ronnie literally went and told Stanley that, because he was a bail bondsman. So he wanted to make sure that if Quincy got, picked up, that he could have a bail bondsman to bail him out, right? So now all the pieces are like coming all the way together now that we have this conviction, right? And I'm so glad that the jury was able to see through everything that the defense was trying to put up and trying to put this on this man that, unfortunately, at the time, he's homeless. Like, he was literally still in jail. They gave him a bond and he had to wear an ankle monitor. And unfortunately, Robert Quincy, it wasn't even in a position where he had a home to go to so they can have an address for his ankle monitor for his house arrest. So he was still in jail just because of that, not because of any bond money or he waiting to go on trial or anything like that. They gave him bond and he couldn't get out. So what kind of situation that he was in, right? Right. But, yes, Benny. Ronnie knew what he had done and he wanted to be prepared for that bond, right? Right. And I think he just mentioned it to Stanley just to try to see, hypothetical, if it was Quincy, to kind of, maybe he wanted to see how it goes in regards to getting a bond, if he can get a bond. But how dare him? Like, really? Oh, wow. I tell you, I think that the prosecution's opening statements were awesome. You guys let me know what you think in regards to the prosecutor statements. I am going to be checking to see. I know they went on break, lunch. I am going to check their um their feed to see where we're at in regards to this. They're still in recess on their lunch break at this point in time. You guys, y'all put a one in the chat. Do y'all want to hear the prosecutor's opening statements again or anybody's testimony again? Because I can definitely pull it up and we can look at it and review it. Right. You say you glad we here now. And I don't think they're gonna have a hard decision. Like I don't think the jurors will be back there and I'm determining for a long time, Benny. Like I think that they're gonna be back there and they're gonna be quick, especially the way he came out like boom. Hey, this is not the first time. Do you want me to play it again? Okay. Okay, I can do that. Give me 1 second. I'll get it queued up for us and we can listen to that again because I mean the way he came in was really like tough, like no, this is what's about to happen. So guys, we're gonna rewind, we're gonna listen to the prosecutors opening statements again while we wait for them to come back. It shouldn't be long before they come back. Give me 1 second here. I'm getting everything together for us. Because I definitely want to make sure y'all hear the boom. Because it was definitely a boom.
Ladies and gentlemen, Alexia Alexander is not the first person Ronny Walker has killed. See, back in October of 2003, a woman by the name of Elaine Caldwell was shot in the head. Her home was broken into, a robbery was taking place, and ultimately, that man seated right there, Ronny Walker, was convicted of her murder. That, ladies and gentlemen, is an aggravator, and one of the two the state will prove beyond a reasonable doubt, and which makes Ronny Walker death eligible. We are now at the stage where guilt is not an issue. You have already found the defendant guilty of the crimes he was charged with, and so now we are at the stage which is called the penalty phase. The issue now is your determination of whether the sentence should be life in prison without parole or death. The state will be presenting two aggravating factors. One of the aggravating factors, and I'm going to get into in a minute, that you've already really kind of heard of and heard through the evidence, because here you can still consider all the evidence that was presented in the case, in the guilt phase. Okay, so one of the aggravating factors is an aggravating factor called cold, calculated, and premeditated. And you're going to learn what exactly that is and what the state has to prove. The other aggravating factor that the state has claimed in this case is a prior violent felony conviction. And that is the death of Elaine Caldwell at that man's hands. Now, although you probably don't need any reminding of the process that both Ms. Fawcett and Ms. Schlemmer covered so thoroughly during the voir dire, the state must prove at least one of those aggravating factors beyond a reasonable doubt before you can even consider death. I think you've heard that even in the judge's preliminary instruction. And we have no doubt that you will find both aggravating factors have been proven beyond a reasonable doubt, but you need at least one of those aggravating factors proven beyond a reasonable doubt by the state before you can then consider death. And again, everything that was presented and argued in the guilt phase can be considered by you when considering certain aggravating factors. And in this case, that is the cold, calculated, premeditated. So the state is not going to come and have to represent all of those witnesses and all of that evidence. I think you all would go crazy. No, you can consider all of that. It is considered part of this trial as well. So let me talk to you a little bit about cold, calculated, and premeditated. And obviously this is a aggravator where there is a heightened premeditation it's calculated and it's done in a very cold manner. So in this particular case, you heard evidence from Robert Quincy Creed that he was searching for her, clearly had a plan in mind.
Judge, may I read?
Yes.
And again, we're not going to represent all this. I'm just showing or explaining to you some of the things that you heard that may apply. But the fact that he was searching for her, that he got her in the car, bought her a drink, and took her, most importantly, to this location in the middle of the night, a dark location, according to Quincy Creed, a location where he pulled up so that the car was easily accessible on the driver's side to that vacant lot where her body could be left. All shows, ladies and gentlemen, heightened premeditation. And all of that is evidence you already have and evidence that you can consider when determining whether or not it was cold, calculated, and premeditated. And then you heard from Quincy Creed she was shot in the car. And as I described to you earlier, the evidence we believe showed that she walked out of that car and that Ronny Walker confronted her in that vacant lot and shot her 3 times in the head. That is basically an execution style killing.
Objection, Your Honor, improper argument. And same arguments made at the bench.
Yeah, I'll sustain.
So you can consider how she was shot in determining whether or not this was a cold, calculated, and premeditated kind of case. All of that the state believes will add up to cold, calculated, and premeditated. That is one of the aggravators. And again, you're not going to hear a bunch of evidence. That's why this is going to be a much shorter presentation for you all. We're not going to go back through all that. We're going to rely on your memories of all of that and informing a decision as to whether or not that aggravator applies. The second aggravator, however, is one you have not heard or learned about until today. So we do intend to present some evidence. It's still going to be very short and it's not going to be as significant. We're not going to relitigate that case. We're not going to do all that, but we are going to present a couple of witnesses, or at least one witness, to tell you sort of what happened there. Give you a little bit of the facts surrounding what occurred so you can kind of understand about the prior violent felony. And you're going to hear about Elaine Caldwell, and you're going to hear how this was her home that she was in when Ronny Walker came in there. You're going to hear about the fact that this was a robbery. And that because of them breaking into the home, it was a burglary. That there was another accomplice with that individual. You're going to hear that she was shot in her bedroom and shot in the head and killed. You will see certified copies of convictions that indicate Ronny Walker was convicted of those crimes. You'll hear from the lead detective at the beginning of the investigation, who will describe to you the scene. And he will also tell you the attended the autopsy and describe to you the injury that Elaine Caldwell suffered. All of that will be brought to you. Again, in a more truncated fashion, but a way for you to understand what happened in that prior violent felony conviction. Those 2 aggravating factors will be proven to you beyond a reasonable doubt. And at that point in time, you can consider whether to sentence Ronny Walker to death or life in prison. You will then decide whether each aggravating factor can sustain a sentence of death. And I submit that you will most likely hear mitigation for Ronny Walker. And you will need to consider all the mitigation the defense provides and give it whatever weight you feel it's appropriate. Then you will weigh the aggravating factors that the state believes it will prove to you beyond a reasonable doubt against those mitigating circumstances that you will hear about. And again, you give each the weight you feel they deserve. And then if you find that the aggravating factors outweigh those mitigating circumstances, and again, this must be unanimous at this point, then you go to the ultimate decision, and that is whether or not the defendant should be sentenced to death. We are confident, ladies and gentlemen, that we will have proven our aggravating factors, that you will give them great weight because they deserve great weight, and that you will find these aggravating factors outweigh the mitigating circumstances you're going to hear, and that the appropriate sentence in this case is the sentence of death.
Thank you, Judge. May it please the court, counsels. Good morning. My name, you haven't heard. We want to thank you for the service you have done in this case. It has been over 2 weeks that you have been with us. The time and attention you have given.
I know. I'm coming in softly, Benny. Real softly. So hopefully y'all don't come blaring through your ears. Okay, so guys, after rehearing that opening statements from the, I know, Benny, that's why I stopped it. I figured you would want to hear me versus to her. Try to plead this man's case, right? So after hearing that opening statement from the prosecutors, like I said, we're going to hear a trial within a trial, which is like, wow. Like, it's not too many times that you get this. And if you're anything like me and you're an advocate trial watcher, the things that I get excited about is when I can hear a trial within a trial and when the defendant decides to testify. Boy, oh boy, when they decide to testify, I can't wait. Like, let me see what you're going to have to say about this. How are you going to spin this narrative on this case? And it's not too often that defendants testify, and it's not too often where we get a trial within a trial, like he committed another heinous act, right? So that is pretty interesting to know. It looks like they are still on recess. They have not got back. And trust me, this courtroom don't do times really, really well. So Benny, I know, right? Yeah, absolutely. Yeah, that's right. Yeah, so we getting like a 2-for-1 deal in this situation, um, in regards to it. So do y'all think, like, when we're looking at this, what do you think from your end? Do you put a 1 in the chat if you feel like death penalty, like he should be sentenced to death, right? Or let's put a 2 in the chat if he should just spend the rest of his life in prison. Y'all let me know what you guys think. I think I know where most of you probably are heading, especially when we didn't found out that he has another conviction. Look, I can't even talk right now. Conviction for murder, but it's like, wow. And for, I know that the defense is, trying to present this, hey, he had all this PTSD, emotional stress, just different things. But just thinking about the way he tried to carry this out and put it on someone else, and knowing that he had already been convicted of a crime and he was released from jail. And I don't know how he was released. I'm going to look up the documents and paperwork in regards to that. So to figure that out, matter of fact, because they're still in recess. Let me see. I'm gonna see if we can find out some information. Give me 1 second. I'm gonna look up and see what we can find. Let's see what we have here. Yeah, just coming up with a lot of things in regards to this current case right now, from what I can see. And then to hear, even when they're with their statements in regards to the defense, that this man got 3 children, 2 boys and 1 girl. Like, as a father, like how would you feel in regards to that? Like, really? Wow. Anna says she doesn't think that he was even out long before he committed this crime. I tell you, like, wow, like, and this really, makes you think, like, it's hurtful for the people that are put in these situations where they commit a crime and they get this opportunity for a second chance, and they have all intentions to come out and do good. But then you get people like him that they get that second chance, and now we know why you were in there the first time. Like it's just heartbreaking. It's just heartbreaking. And I know this is going to be like rough for the family, in order to make this, their statements and things like that, like, and express. And I'm not, I know that her adoptive mom was on the stand, right? But I don't know if her biological mom, if she's aware, or I know that the adoptive mom, when she got on the stand, she was stating that Alexia had some issues when she reached out to her biological mom. And that's what started causing her to kind of like spiral out of, I don't want to say out of control, where she was like running away all the time, having difficulties with dealing with that. So I don't know if the biological mom is involved at this point in time or not, in regards to knowing that her child, has been unalived by this man here. Let me see. I'm still checking in regards to the courtroom feed. You're still at lunch. Of course, we don't have no TiVo time. Okay, so Anna, you tried to find out about info on the case, but it's been difficult. Yeah, when I'm doing it, when I'm searching it, the only thing that's coming up is in regards to the case that we got right now. It's not really showing anything additional in regards to it that I can see. I'm pretty sure with some more research and stuff, I can probably definitely find some stuff for it to present if I come across of it, because it seemed like we're going to be in court for a couple of days with the witnesses and things that they're going to be presenting. And of course, because we're going to have a trial within a trial. So we'll probably be here for a couple of days. So I'll definitely research that to see if I can find something and bring it to you guys. Because I don't know if the prosecution is going to immediately start off with the information in regards to it. in regards to the other case, or if they're gonna bring it in, trickling it in as we go along in regards to their case in chief that they're gonna present. But yeah, let's see here. So y'all let me know, do y'all want to listen to anything else while they're on break, or does anyone want to talk about it? I can also drop the link if you want to come over and talk. You let me know. This is your world, justice seekers. Let's see here. They have me looking at a beach. On their screensaver is a beach. For what I can see. Let's see. Yeah, so it's still currently in recess. So is there anybody's testimony from the first trial that y'all want to listen to, or do y'all want to finish listening to the defense? I know you don't, Benny. I know you don't want to hear. Does anyone else want to hear the defense opening statement, the rest of it? Okay. Okay, we can do that. You talk about in the first trial, correct, Benny? Okay. I'll get that queued up and we can listen to that until court goes back into session. Give me 1 second. I'll get it pulled up for us. At least we can go back to and actually, as justice seekers, see how the prosecution laid out that information in regards to the case and where they went and how they proved it, right, from their opening statements. And their opening statements for either party was not that long, so that's the one good thing about it. Let me get it up for us. Give me 1 second. I'm gonna get us right where we need to be. Okay, here we go, guys. This is, if you're just now coming in, we are currently on recess right now on a lunch break for the trial with Ronny Walker. We are in the penalty phase. In the meantime, we are just going back to the first trial and listening to the opening statements from the prosecutors and maybe possibly the defense. And I will be checking the courtroom. So if they do come back into the courtroom, I will stop our feed in order to go back into the courtroom live. Okay, guys, here we go.
It wasn't her first time running away from home. She'd been struggling and acting as immaturely. And in that May of 2022, Nylexia made a decision that ultimately led to her death. Because on May the 6th of 2022, at around 3 a.m., Nylexia Alexander got in the car belonging to that man right there, Ronny Walker. She'd been out on the streets. She'd been wandering around. She was in an apartment complex. And she gets picked up by Ronny Walker. You will see, ladies and gentlemen, video of those last minutes of her life. You will hear how Ronny Walker had been driving around looking for her and found her just blocks away from where he was living. You will see these videos. And you will see Nylexia. You will see her walking around with a cell phone in her hand and a cell phone charger around her neck. The video will show her walking into that little area down that little alley. And shortly after that, you will see a black car driven by that man, Ronny Walker, pulling into that same location. From a Ring camera at a residence there, you will see Nylexia Alexander get in the car belonging to Ronny Walker. That, ladies and gentlemen, will be the last time she is seen alive. See, that night, Ronny Walker had decided he was going to kill Nylexia Alexander. He found her, he got her in the car, and drove away. You're going to hear that he drove to a convenience store where he bought her a drink. One can only assume that at that time, Nylexia Alexander had no idea what was awaiting her. You're going to hear and see from different cameras this vehicle driven by Ronny Walker driving around at that time of the night into different little neighborhoods and on down streets. And it will end up in a neighborhood around Flora, Nebraska and North Highland Avenue. It will end up right next to a vacant field where you see that blue spot. That's a dead-end road in a vacant lot. You're going to see that vehicle pull into there. We have video, ladies and gentlemen, and you will see that car pull into there. The car will turn down onto Flora, Nebraska, drive down to the end of the road. You will see it coming back down Flora, Nebraska, and pause and stop right next to that vacant field. The lights will go off of the car. 50 seconds will pass. The lights will come on, but then immediately the lights will turn back off and the car will drive away with its lights off. During that time, Ronny Walker shot and killed Nylexia Alexander and left her body in that vacant field. This, ladies and gentlemen, is the video you are going to see. And you will see the car. There's a spider web kind of caught in the middle of it, so it misses some of it. But you will see the car turn down that road, turn back up, stop. The lights will go off. 50 seconds will pass. And then you'll see the lights come on. Clearly the car being turned back on. And then the lights will immediately be shut off as the car drives away. car comes back and stops. Right there is when Alexia Alexander is being murdered. Lights come back on, lights are off as the car drives away. We learn what happened in that car. We learn that because we are later able to ascertain the identity of the passenger in that car, Robert Quincy Creed. Robert Quincy Creed tells us that at that point when the car stops, Ronny Walker begins to yell at Alexia. And
Okay, guys, I have paused the review of the first trial's opening statements. We are live back in court, so I'm going to take us back into the courtroom in regards to the first day for the penalty phase trial. I'm going to put us back in there, and I'll pause it right where we're at here just in case we want to go back and listen to it if they take any breaks or anything, considering that, unfortunately, we don't have any TiVo time today, right? So let me get that up for us. And get that over here for us. And we're going to listen in regards to Mr. Walker.
Is your witness out there, the one I need to?
No, he wasn't out.
He's there, and then I can just do this one with the delay.
He wasn't out there, Judge, when TJ checked. He wasn't out there when TJ just checked.
Okay. All right, we're good.
All rise for the jurors.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. Once again, no issues with the court instructions, no one approached you talking about the case, you didn't see the media, you talked about it amongst yourself. Perfect, very good. Mr. Chair, whenever you're ready.
Yes, Your Honor. Judge, at this point in time, prior to calling our first witness, the state would move into evidence for this portion of the proceeding, State's Exhibit 2A and State's Exhibit 2B.
Any objection?
No objection, Judge.
States 2A and 2B will admit it.
Judge, and if I may publish these to the jury.
Yes, sir.
And these are the certified copies of convictions. And this is 2A, which is the certified copy of conviction for case number 09-CF-015021. And I'm now going to publish 2B, certified copy of conviction for case 10-CF-006452.
May we approach?
Yes. Ladies and gentlemen, just a reminder, those two certified copies of convictions are from the same event. It's the same charge.
Judge, this time the state would call Dennis Drabanak.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Thank you. Good afternoon, sir. If you can tell the jury your name and spell your last name for the court reporter.
Name's Dennis Drabanak, D-R-A-B-I-N-I-A-K.
All right. And sir, how are you currently employed?
I'm retired.
Okay. When did you retire?
I retired from TPD in Tampa Police in 2010.
All right. After working with Tampa Police, did you work anywhere else after that?
Yes, sir.
Where did you work after that?
State Attorney's Office for till last year.
All right.
14 years.
And you were an investigator at the state attorney's office?
Yes, sir.
All right. Now back, you said you retired from TPD. What year was that?
2010.
Okay. Prior to retiring at Tampa Police Department, what positions did you hold at that department?
I was a detective for most of my career. Narcotics first as a young man, then homicide, then a trip around patrol, and then back at homicide and robbery, and then intel at the end.
All right. Now, back in October of 2003, what position did you hold at the Tampa Police Department?
In 2003, I went back to homicide.
Okay. And were you involved in the initial investigation into the death of Elaine Caldwell?
Yes,
And what position did you hold in the investigation?
I was a lead detective at that time.
All right. Did you respond out to the scene?
Yes, I did.
Okay. Describe for the jury, if you can, the scene when you arrived at the location.
It was pretty chaotic. Quite a few people there. The street was full of people. It was at the 2013 Eskimo, Hillsborough County, Florida. And so I got there. I met with another detective, and was briefed by the on-scene supervisors and the adverse detectives, and then initiated our investigation.
All right. What was this location?
It was a 2013 Eskimo.
What was it? Was it a home?
It was a house. It was a residence. Excuse me.
It was a residence? Okay. And was there a crime scene tape out when you arrived?
Yes, there were.
All right. And was the scene actually inside the residence?
Yes, it was.
Did you go into the residence?
Yes, I did.
What did you observe when you went into the residence?
Well, when I went to the residence, I met with one of the people there that was Raymond Lee. Met with him. I met with a little girl, and then spoke to him for a minute, and then he showed me where the decedent Elaine Caldwell was.
Did he give you information as to what took place or what had just happened?
Objection, hearsay.
I'm not asking him what information. Did he give you information about what had happened?
Yes.
And did you speak with the young girl that was there as well?
Yes.
Was she able to also give you some information about what happened?
Yes.
Okay. And where was the victim, Elaine Caldwell, was she still at the scene?
Yes.
Where was she?
In the master bedroom.
All right. And did you go in and find her or see her?
Yes.
And what was her position? How was she positioned?
She was at the foot of the bed between the end of the bed and a dresser. It was a narrow area. And she was slumped down on her knees. Part of her body was on the mattress, the foot of the bed.
So at that point in time, you kind of took over or were the lead in the investigation, correct?
Yes. Yes, sir.
And you said you obtained the statements from the witnesses who were present at the time?
Yes, sir.
All right. And after all of that, did you later attend an autopsy in this case?
Yes, I did.
And that was the autopsy of Elaine Caldwell?
Yes, it was.
I'm going to show you what's been marked as states 5A1 through A3. You can take a look at that. Look at those pictures, please. Do you recognize those?
Yes, sir.
And what are they?
They're photographs of Elaine Caldwell.
And do these pictures fairly and accurately represent what they are showing in these pictures?
Yes, sir.
Judge Mudaz states exhibits 5A1 and through A3 admitted into evidence.
Defense,
Same objection.
same rulings, and they may be published.
All right, thank you. In states 5A1, what are we looking at here?
We are looking at the DL driver's license photo of Elaine Caldwell.
All right, and this was the individual you found dead in that residence when you arrived there that day. Is that right?
Yes, sir.
All right. In states exhibit 5A3, what are we looking at here?
Photograph of Elaine Caldwell at the medical examiner's office.
And you, in fact, went there and you were present while the autopsy was conducted in this
Yes.
case, correct? And what injury did she have?
She had a gunshot wound to the head.
Showing you what is marked as 5A2. Was this in fact the bullet wound that you observed that day to the head of Elaine Caldwell?
Yes, sir.
Now, Detective, did you ever finish with this case or solve this case?
No.
Okay, so there was a certain point, was there a certain point in this investigation where you moved to a different unit or different area?
Yes, sir.
But you were the initial lead and you were the one who responded to the scene as well as to the autopsy, correct?
That's correct.
All right. I may have a moment, Your Honor.
Yes.
Nothing further. This witness.
Good afternoon.
Good afternoon.
Just one or two questions for you. So when did you leave the unit or when did you retire?
I retired from the city in September of 2010. Excuse me. I left the unit, I believe, in 04.
Okay.
I went to,
This incident with Miss Caldwell occurred in 2003.
yes, ma'am.
Okay. And then you left the unit in 2004
That's correct.
and officially retired in 2010.
Yes, ma'am.
All right. And when you left the unit, the case went cold, correct?
Yes.
Yes. Okay. May I have a moment?
Yes, ma'am.
No other questions? Thank you.
Can you redirect?
No.
Can you finish the excuse?
Yes.
Free to go. Thank you.
Thanks, sir.
Statement, call your next witness. Yes, come on. All right, ladies and gentlemen, we're gonna take about a 2-minute recess, so if you'll just keep them close, we're gonna bring them right back.
All rise for jurors.
Teresa, look for room, y'all may be seated. Go ahead. bring them in. We're just gonna swear you in, I have to ask you a couple of questions.
Do you raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir.
You got a chance to talk to the attorneys about what you can and can't say, correct?
Correct.
This could be real important that you stay inside what they told you not to say. Because if you get emotional and you say things that you may want to say, that you're not supposed to inside of the courtroom, then this whole thing's gonna have to start over from the very beginning. And we don't want to go down that road, right? So just make sure that whatever those attorneys told you about what you can say, go ahead and say that and stay away from anything they told you not to bring up. Okay, I really want you to do that for the court, all right?
Okay.
I appreciate that. You can go ahead and have a seat, sir. Thank you for coming down here.
I'm just gonna put it on the record so that it's clear.
Okay. She's just gonna repeat it so it's in the record. What we can't say.
Good afternoon, sir.
Good afternoon.
Okay. Well, I know that one of the ways that you knew or that you found out the person that was in your home was that you looked at the Florida Department of Corrections website. Is that correct?
Yes.
And you knew that the person had just come out of prison. The one thing that we cannot mention is the Florida Department of Corrections website or that the defendant had ever been to prison or had just come out of prison. So whenever I ask you questions, I'm really just going to be asking you about October the 23rd of 2003 and the events of that day specifically. Okay?
Okay.
All right. Thank you, sir.
Appreciate that.
Judge, before the jury, since he's already on the stand, before the jury comes in, we renew all objections to the testimony.
Same rules.
Thank you.
All rise, jurors entered.
thing. We looked through your thing. You have 6 prior felonies. So they asked how many prior felonies you have. 6.
Okay.
Remember that number?
Thank you. You all may be seated.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your full name for the record?
Raymond Jerome Lee.
And sir, are you currently employed?
Yes.
Where do you work?
At Midwest Transportation.
Okay, and how long have you worked there?
2.5 years.
So I'd like to turn your attention to the time frame of October the 23rd of 2003 at about 8 p.m. Where were you at around that time on that day?
Home.
Okay. Where did you live?
I don't forgot the address, but on Eskimo in
And
Tampa.
That's in here in Hillsborough County, is
Yes.
that correct?
Yes, correct.
Who were you living with?
Me and Elaine Caldwell, my girlfriend.
Okay. Was there anyone else living in the home at the time?
Yes,
Who?
a daughter.
How old was your daughter?
Was
Objection, relevance?
Sustained.
So at the time of October the 23rd of 2003 at 8 p.m., what were you doing at your home?
I was watching television in the den.
Were you with anyone in the den?
Yes,
Who were you with?
my daughter.
And was Elaine Caldwell home as well?
Yes, she were.
Where was she?
She was in the bedroom doing her hair.
And did something out of the ordinary happen?
Yes.
What happened?
I had someone come into my house that wasn't invited in my house.
And what did the person do?
Well, he came in with a gun. He came in to rob me.
So when this individual came into your home, do you know if he had anything covering his face? Did he have a mask or anything on?
No, he didn't have no mask on. He had a hat on, but he didn't have no mask.
And did he speak with you? Did he say anything to you?
Yes, he would ask who was all in the house.
And what did you say?
My girlfriend, Elaine.
Okay. And at that point, what happened after you said that to him?
He asked me to get up, and me and my daughter got up, and he walked us into the next bedroom where she was at. And once I called her, I say, Linnell, and she,
Objection, hearsay?
You can answer the question.
okay, and she turned around and looked and seen the 3 of us.
Objection, speculation?
Rephrase the question.
What happened after you entered the room, the bedroom with Elaine Caldwell?
Ronnie attempted to with the gun, and she started screaming when she saw an uninvited guest behind me with the gun to my head, and she just started screaming hysterical.
And then what happened after that?
And okay, so when she was screaming hysterical, and I kept telling her to be quiet, and he kept handing the gun to my head, and he kept saying, well, where's the money? And she kept screaming, and then he pointed the gun at her, and he kept saying, be quiet, and I kept trying to tell her to be quiet too. And then my daughter was crying also and stuff. And
Objection, relevance?
Go ahead.
and my daughter kept screaming, and she was crying and stuff too. And then Ronnie had pointed the gun, and he told her that he wasn't gonna hurt her, and he kissed her on the forehead and said, I'm not gonna hurt you and stuff. So he pointed the gun back at Elaine because she kept screaming and stuff. So what I did was I reached for the gun, and we went to tussling with the gun and stuff like that. And the gun went off. I thought that the it shot up in the ceiling, but it hit her in the head.
Okay. Did you see Elaine Caldwell get hit in the head or get shot?
Yes.
And then how did she react after she got shot?
Well, she fell.
Okay. What did the defendant do after that?
We all, 3 of us, we all freaked out. You know what I'm saying? That the gun went off in the bedroom, and seen her fall and stuff. And he kept saying where the money was. And then my daughter said, it's out there in the car. It's in the trunk out there in the car and stuff. So he was leading us out, going out the front door and stuff. And once we did get out the front door, I pushed my daughter and I told her to run and stuff. And Ronnie ran down one way and I ran across the street trying to get help.
At some point, did you give Ronnie Walker money?
Yes.
Okay, how much did you give him?
Probably about $500 I had in my back pocket.
At what point did you give him this money? Is it before you went into the bedroom with Elaine Caldwell or after?
I can't quite remember, but I think he probably took it before we went in the bedroom with Lanier.
So after Mr. And do you see that person who was in your home and shot Elaine Caldwell in the courtroom today?
Of course I do.
Can you please identify him by an article of clothing?
Yes, right there with the gray suit on with the sunglasses or whatever shades on. Sent to the table right there.
You want to
Never
make the record reflect the witness has identified the defendant?
Yes, sir.
Okay. And so, do you know which one happened first in time? Do you remember whether when he entered the home and he asked you for money, whether he ultimately got that money from you before you went into the bedroom?
On a scale from 1 to 10, I give it an 8 that he took it. I gave him the money before we went into the bedroom.
Okay. And do you remember Mr. Ronny Walker still asking for more money?
Oh, of course.
Okay. So tell us what happened at that point.
When we was in the bedroom,
Answer, Judge.
Sustained.
After you gave him the $500, was there a time that he asked for more money?
yes, when we walked into the bedroom. See, he took the money from me while we was in the den. As we was walking to the room where Elaine was doing her hair at, right? That's when he kept asking for more money.
Okay. All right. And after Elaine Caldwell was shot, did he continue to ask for more money?
No.
Did he take you outside for more money?
Right. Yeah, we walked back outside because my daughter had said that it's in the.
Objection, hearsay.
Goes to, okay. You can answer the question.
She said that it was in the trunk of the car. She was saying that to get him
Objection, speculation.
out of the house.
Hold on. Sustained.
All right, Judge, I'd ask you to strike that.
Strike the last statement.
Did you walk out of the house with Ronny Walker and your daughter?
Yes.
Ask and answer, Judge.
Sustained.
Under what circumstances did you walk out the house, out of your home? After
Ask and
Elaine,
answer, Judge.
may we approach?
I'll overrule that, Judge.
Under what circumstances did you walk out of your home after Elaine Caldwell was shot?
Up under the distress of Ronny Walker with a gun, walking us, we going out the front door.
Did he still have the gun pointed
Of-
at you?
Of course.
At any point during this incident, did Ronny Walker also have the gun pointed at your daughter?
Yes.
Objection, relevance.
Sustained.
It goes to the aggravator, Your Honor.
I'll sustain the objection.
Okay. At any point in time, did Ronny Walker have the gun specifically pointed at Elaine Caldwell?
Yes.
Judge, I would ask for an answer concerning the daughter. And ask, tell the jury to disregard.
May we approach, Your Honor?
No, I'll strike it.
Did you ever give Ronny Walker permission to enter your home?
No, I didn't.
Did you know Ronny Walker before this day, October the 23rd of
No.
2003?
No.
Your Honor, may I have a moment?
Yes, ma'am.
I have no further questions.
Cross.
Good afternoon. So, sir, you've been convicted of 6 felonies, is that correct?
That's correct.
Okay. And you indicated that Mr. Walker, who you've identified as being in your house that day, had kissed your daughter's head and said he was not going to hurt her, correct?
Correct.
And he had said he's not going to hurt her because he has 2 daughters of his own, correct?
Correct.
Right. And you indicated and you told the jury that basically you are tussling with him at some point, and that's when the gun, quote, goes off, correct?
Correct.
And at some point, Mr. Walker tried to get out of the house, didn't he?
Of course, all of us tried to get, yes.
Before that, didn't he try to exit the home?
Before that,
Yes, before you walk out to the car with Mr. Walker and your daughter, doesn't he try to get out of the house?
no.
You didn't just tell me that in deposition?
No, when I said what I said was we all was going out of the house, not him trying to get out of the house on his own and leave us in there.
Okay.
We was all going out to the car, so-called, to get money from out of the trunk of the car.
Okay, understood. So are you denying that you just told me under oath in deposition?
Objection, Your Honor. Improper impeachment.
Sustained.
Well, let me ask you this question
Okay.
and see. Did you in fact just give us a deposition?
Yes, I did.
Improper impeachment.
Overruled.
Did you just give us a deposition?
Yes, I did.
Were you placed under oath at the time? to
Yes,
tell
I
the truth?
were.
Okay, and did you speak with myself and Miss Fawcett?
Yes, I did.
Right? All right. Let me ask you, did you make the following response to the following question or the following response and tell us that at some point before you walk outside with Mr. Walker and your daughter, Mr. Walker was trying to get out of the house on his own?
Maybe I misunderstood
Okay.
what you were saying.
Everybody.
If I
quiet.
did,
Hold
if
on.
I,
One at a time. Don't speak over each other, because this young lady right here can't write down 3 conversations that are going on. So there's been an objection, grounds,
Improper impeachment.
overruled.
Okay. All right. And you indicated that Ronnie asked for money. Is that right?
that's correct.
And he was asking that several times, right?
That's correct.
Okay. And may I have a moment, Your Honor?
Yes, ma'am.
No other questions. Thank you, Mr. Lee.
Do you read?
No, Your Honor. Thank you.
May this witness be excused?
Yes.
Thank you, Susan. Step down. State your call next witness.
Your Honor, at this time, the state would call Ashley Alexander.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Well, Ms. Alexander is approaching the podium. May Ms. Fawcett and I approach?
Sure, come on up. Well, ladies and gentlemen, once again, I'm going to read you partial part of the original instruction I gave you. Once again, the state is about to present evidence of the existence of an aggravating factor. Victim impact evidence may be presented. Such evidence is only presented to demonstrate Alexia Alexander's uniqueness as an individual and the loss to the community by the victim's death. However, the victim impact must not be considered by you as an aggravating factor.
Judge, may we approach?
Yes. Once again, ladies and gentlemen, victim impact evidence may be presented. Such evidence is only presented to demonstrate Alexia Alexander's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Thank you. You may proceed.
Thank you. Good afternoon, ma'am.
Good afternoon.
Can you please state your full name for the record?
Ashley Alexander.
And ma'am, how are you related to Nalexia Alexander?
I'm her mother.
Did you prepare a victim impact statement?
Yes, ma'am, I have.
Are you prepared to read it?
Yes, ma'am, I am.
Okay. She may proceed.
Whenever you're ready, ma'am.
My name is Ashley Alexander. I am the mother of Alexia Alexander. I became Alexia, which we call her Lexi, foster mom, June of 2011. I remember when Lexi came to my home, she was a fragile little girl who was scared and nervous. But she became warm with love. She opened up as she got more comfortable in my home. Lexi was my gentle giant. She was sweet, loving, and caring. She gave the best hugs and kisses. My baby was always smiling. She wasn't confrontational with anyone. If you asked her for a shirt off her back, she would give it to you without hesitation. Lexi was always loving, outgoing, and she was always wanted to do anything to help everyone that she could. The past 2 years having the girls, I grew very fond of Lexi and her sister. So in April 2013, I decided to adopt Lexi and her sister. Not only because I love the girls, but because I wanted them to have a forever home. We always did fun things such as picnics, going to the beach, and of course, the pool every weekend. Lex loved water. Lex loved happening in the kitchen, cooking, and preparing the meals for our dinner movie nights. When she was younger, Lex and her sister and I would always sit in a room and watch a Disney movie. Frozen, Monster High was our favorite. She loved Shopkins, and for Christmas, she always told me, Mom, I want all Shopkins, everything. So I would take the girls to my mom's house later at night just to go out looking for Shopkins in the store. I went from Walmart to Toys R Us, Target, and Ross. Wherever they had kids' toys, I was there. As Lexi grew older, I had to learn to adjust and grow and change with her personality. As she became a preteen, she got into the different hairstyles, different music types. She loved to dance, sing, and dress up. Lexi had dreams of becoming a fashion designer. She wanted to graduate high school and go to college in New York City. She wanted to study fashion. She also wanted to study to be a lawyer. For her 15th birthday, my mom and I were going to surprise her with a trip to the Big Apple, as she could see her dreams can come true and get the experience of traveling on a plane, something she always dreamed of. I miss the conversations. I miss sitting on the porch talking about her school days and talk about the school dances that were coming up and how she wanted her hair done and the dresses she wanted to wear. I miss listening to her dreams and all her desires. I miss her climbing in my bed and wanting her head rubbed as she fell asleep in my lap. I thank God for allowing me to be Alexia's mom for the 12 years.
Thank you, ma'am. Showing you what has been pre-marked as City Exhibit 4A through J. Do you recognize these photographs?
Yes, ma'am, I do.
Are there an accurate depiction of Alexia?
Yes, ma'am, it is.
Your Honor, at this time, the state would move into evidence State Exhibit 4A through J.
Same objections, Judge.
Same rule, I'll allow it.
Publishing, State A through J. State Exhibit 4A. Ma'am?
Yes,
You
ma'am.
look that way, or? Is this Nylexia?
Yes, ma'am.
Do you remember what was happening at this point?
That was her 4th birthday. It was at Chili's celebrating.
State Exhibit 4B.
First day of kindergarten.
4C.
Christmas, I want to say she was about 11, 12. It was at my mom's house.
Did you put these enhancements?
I did, from
Okay.
Snapchat.
State Exhibit 4D.
We was going shopping. She was about 13 here.
And did Alexia put these enhancements?
Yes, ma'am. She always had my phone on Snapchat.
Okay. State Exhibit 4E.
She was actually 10 on this picture at She High Elementary. She was in 5th grade. She was a patrol.
State Exhibit 4F.
She was about 7, and we was all going out to dinner.
Okay. State Exhibit 4G.
That was Christmas of 2021, and she was 13.
State Exhibit 4H.
She was 12 on this picture.
State Exhibit 4I.
Her 5th grade banquet at She High. That was her 5th grade banquet at She High.
And State Exhibit 4J.
That was just one Sunday, was at my mom's house, sitting at the table, and my mom was making a joke, and she just turned around and had this smile on her face, and it was a moment to catch her. And she was about 11, 12.
Thank you, ma'am. You're not.
Oh my God, I'm sorry.
We have no questions.
Okay.
Oh, I'm sorry.
All right. Thank you.
Next witness.
Yes, the state would call Leslie Alexander.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Good afternoon, ma'am.
Good afternoon,
Can you please state your full name for the record?
Leslie Alexander.
And how are you? How do you know Lexi Alexander? How did you know
She's
her?
my granddaughter.
And under what circumstances did she become your granddaughter?
When my daughter started, she fostered her, and then we all fell in love with her, and then she decided to adopt them.
Okay. And if you could get closer to the microphone. Did you spend a lot of time with Alexi Alexander?
I did,
Did you create a victim impact statement?
yes,
Are you prepared to read it?
yes.
Okay, thank you.
My name is Leslie Alexander. I am the mother of Alexia Alexander. Friday, May 6, 2022 is a day that I will forever be etched in my memory. I was on my way to dinner with friends when I received the call that Alexia was dead. My first thought was that there must have been some kind of mistake. I could not believe, but it was true. Alexia, or Lexi, as we lovingly call her, was a social butterfly and a girly girl. She loved getting her hair, nails, and toes done. From the age of 5 to 8, she and her sister would spend weekends with me because their mother worked every weekend. We would start our mornings with her favorite breakfast: waffles, eggs, grits with cheese, bacon, sausage, and fresh fruit, which she loved having to prepare. We would sit out on the lanai, eat and talk. Then we would begin our manicures and pedicures. She and her sister would pick their favorite colors, and I would polish their nails and add a design of their choice. If I were having a difficult day, Alexia would say, "Nana, I know what we can do to cheer you up." When I asked her what, she would say, "Shopping." So off we go to our favorite stores: Dillard's, Nordstrom's, and Macy's. Lexi always talked about going to New York. We were planning to surprise her with a trip for her 15th birthday. Sadly, we never had the chance. She was such a loving and beautiful child, and her absence has left a hole in our hearts that can never be filled. One of Alexia's favorite hobbies was baking cookies. She especially loved baking chocolate chip cookies. I remember how excited she would get gathering all the ingredients. She took pride in measuring everything perfectly and always insisted on taste testing the dough. The kitchen would fill with the sweet smell of cookies, and she would light up with joy when they came out of the oven. Baking together became one of our special traditions, and those moments are now some of my most cherished memories. Now, Alexia loved to dance to her favorite song, Girl on Fire by Alicia Keys. Even though she had no rhythm, but she was having fun like any typical teenager. She will forever be in our hearts and deeply missed.
Thank you, ma'am. Thank you.
I don't know questions.
You can see the thing.
Thank you. Yes, the state would call Miss Gatson Yarborough.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am.
Councilman, are you ready?
Thank you. Could you please state your full name for the record?
Delia Gadsden Yarborough.
Okay. And ma'am, are you currently employed?
Yes, I am.
Where do you work?
Hillsborough County Public Schools. I was the principal at Shehigh, and next week I'll be the principal of Muller.
Congratulations.
Thank you.
Do you know Nalexia? Did you know Nalexia Alexander?
Yes, I did.
How did you get to know her?
She was a fifth grade student my first year as principal at Shehigh.
Did you prepare a victim impact statement?
Yes, I did.
Are you prepared to read it?
Yes.
Thank you.
As the principal of Shehigh Elementary during the 2018-2019 school year, I had the privilege of knowing Nilexia Alexander, a remarkable fifth grade student we all called Lexi. She was a dedicated safety patrol and had a heart for helping others. She loved helping her teachers and younger students. She was a bright, kind-hearted girl who always proudly wore her patrol belt. I remember her enjoying all of the end of the year fifth grade festivities, especially getting dressed up for our awards luncheon in a pretty purple dress. I also remember how excited she was to ride in my car to the annual patrol luncheon we hold at Big John's Barbecue every year. I remember how she giggled and laughed when she was talking with her friends. She was happy and enjoyed school. One memory that remains etched in my heart is the day she surprised us after she had moved on to Sly Middle School. She walked in the blazing heat all the way back to Shehigh just to say she missed us and to see all of us. I remember seeing her come up to the car line, hot, tired, and flustered, but beaming. That small act spoke volumes about the love she carried in her heart, even at such a young age. She longed for connection. Tonight, my mind is flooded with images of this beautiful, bright child that would be preparing for her senior year of high school this summer. She will never get to experience high school, prom, graduation, and beyond. In my 29 years as an educator in this community, I've had the privilege of working with thousands of students over the years. Some stand out more than others, but Lexi was truly special. She was always so caring and wanted to be a part of our school even after she moved on. Her smile could light up a room, her laugh was contagious, and her voice was full of kindness. I will never forget Lexi. She will always have a special place in my heart. Her memory will forever remind us of the love and joy she brought into our lives. Respectfully, Lexi's elementary school principal.
Thank you, ma'am.
Thank you.
Thank you.
Thank you, ma'am. All right. Okay. Come on up. Mr. Terry, whenever you're ready.
Yes, Judge. At this time, we would move in all the evidence that was obtained in the guilt phase into the this penalty phase, Your Honor. And with that, we will rest.
Other than previous objections, any other objections?
Same objections made during the guilt phase by Ms. Tucker.
Same rulings that will be all admitted. And state.
At this point, we rest our.
All right, ladies and gentlemen, before I recess for the day and ask you to come back tomorrow at 8:30, I want to remind you that even though there were two judgments that you saw, it was just from one case. And Mr. Walker pled guilty to both of those judgments in that one case. Anything else? All right, court being recessed till tomorrow morning at 8:30.
All right.
Jury's left, y'all may be seated. Any matters we need to discuss outside the presence of the jury? See you folks tomorrow morning at 8:30. Court's in recess.
Court stands in recess. Please exit.
Ma'am,
Good morning.
can you please state your full name for the record?
Ashley Alexander.
Oh my gosh. Wow. 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 What do you guys think of what the prosecution has presented? It was so powerful. I know y'all want to go back and listen to some of this testimony that we saw today. Y'all just put in the chat what y'all want to hear. I know I want to hear about the first murder first, like the first one, because that one was wow. They didn't go in there and piggyback, but that guy's testimony was very emotional. And I would definitely love to listen to that part again. Y'all let me know if y'all want to hear it, because we can always go back and listen to that. Yeah, it was tough. And I know it's tough for the family. I thought they were going to kind of go right into the defense portion in regards to their statement, but I guess they decided that that's probably a lot for everybody today, right? And the jurors get to go home with the last victim impact statements that they received in regards to this crime, right? But yeah, I was like sitting up here with like tears, like get ready to go. I'm like, yeah. I got my little towel here. Yeah, kid you not. I'm like, okay, let me wipe my face. Like, oh gosh. I don't know how many of you out there are parents or the case, but I mean, I got two little girls myself, right? And just thinking about these girls and to hear that a younger life was lost, and she around the age of my girls, and I couldn't even imagine having to go through something like that. And to top it all off, like he was convicted before. Like, why is he out? Like, that is a problem. I don't know. I think that when they come to court tomorrow, that they may have some impact statements for him. Benny, I know that they did say they had witnesses and they wanted to do them by Zoom, but the judge explained that he wouldn't do anything by Zoom. So they were not going to do the Zoom. He wasn't doing the Zoom thing. So I'm not sure if they were able to get the witnesses to actually come in versus to doing the Zoom. But yeah, I think that we may have testimony in regards to that portion tomorrow for his part, because I can't imagine that if the defense wants to make any case to save his life, that they're not going to put on some type of character with witnesses, either the mama, the cousin, maybe a son, daughter, or somebody, right? Somebody gonna have to come up there and say something. If they are indeed trying to, you know, save his life. Like, I don't know, you may have to make up a witness if they can't. They may have to make somebody up to be a character witness for him, if that's their intentions. Because if not, then I don't. I mean, he doesn't stand a chance either way. I don't see the jury saying he can get life in prison. I don't see it. You guys, y'all can let me know which way y'all feel. One in the chat if you feel like he is being sentenced to death, or two in the chat if you think he gonna get life. I'm interested to know. I know some people believe in the death penalty, some people don't. So I'm sure that this jury that they selected had to be open to the possibility of this. So we shall see. So guys, do y'all want to watch anything in regards to any testimony that we've seen today? Do y'all want me to go back to the testimony that we were reviewing in regards to the prosecution's opening statements in the first trial that we heard? Y'all let me know what y'all would like to do. I tell you, wow, that was really something else. That one guy's testimony, and he was heated. He was not happy at all. And we definitely know why. To see that happening, like that happened. I don't think she was his wife at the time, but to see that happen in front of your daughter, and your daughter had to witness her mom being shot. You talking about trauma, and he got the nerve to be talking about some PTSD for him. That's his case. Yeah, right. Like, not today, sir. That won't happen. Like, you should have took care of that before. Okay, so you say the witness regarding the bond, do you want to? Yeah. So Benny, do you want to finish the openings that we were already watching, or you want me to just jump to the witness regarding that bond or full closings in the first trial? Okay, yeah, we got those. Let me see. Closing statements. Let me see. I'm just looking. Okay. So finish out the first one. Okay, so we'll finish up listening to the prosecution's opening statement, and then I'll queue up that witness who had the bond, the Bills bondsman that had I think he had 121 convictions. I think yeah, 121 convictions. Yeah, we'll go back to that one, and if we have time, then we'll go into the full closings from the first trial. Okay, here we go. So I'm just picking up right where we left off.
At this point, she is shot 3 more times in the head, one of them within 12 inches of her face. You'll see the stippling to her face, which a medical examiner is going to tell you means that gun was within 12 inches of her face. intentional, premeditated. Her body's left there on the field. And as you see from that video, the car quickly drives away, lights off. Robert Quincy Creed will tell you that he was sick that night, didn't want to go out, but Ronny Walker insisted that he went with him, that all occurred. He did not know. He will tell you that he believes she was shot in the chest because of the way she was holding her chest, that he did not see how she was shot outside, but he thought he shot two more times. We have audio evidence, ladies and gentlemen. You're going to hear from another camera the actual shots that occurred and the timing of those shots, which was at 3:08 a.m. And you're going to hear one shot, a significant pause, 4 more shots in rapid succession, another pause, and then another shot. 6 times Ronny Walker shot that gun. Shot her once in that car, then shot her outside the car, executing her. Now, Robert Quincy Creed, ladies and gentlemen, is an accomplice, as you know. He was charged with accessory after the fact. He has pled guilty to that. And he has a prior felony record. And you're going to hear that his phone had contact with Nilexia at some point in the past as well. We are not here to tell you that Robert Quincy Creed is completely hands off of this. We know he was involved as well. That's why he was charged. Now, going beyond what Robert Quincy Creed says, detectives are out there. They find out a little while later they receive a 911 call. They go out to the scene and they find a body. Nilexia Alexander. At this point in time, they don't know who this body is. They don't know who she is. And you'll see pictures of the crime scene. You'll see pictures of the body of Nilexia Alexander and how she was discovered abandoned in that crime scene. You will see that the detectives at that point go around looking for cameras, and that's when they find this video. So at this point in time, they have a description of a vehicle. They have Nilexia Alexander's body, who they haven't yet even identified. And that's it. And ladies and gentlemen, that may have been the end of it. A case gone cold with the body of a 14-year-old runaway left on a vacant lot. That could have been the end. But it wasn't. Because Nilexia Alexander left a clue. She left a lead for the detectives. Nilexia Alexander left her phone in the back seat of that vehicle. And Ronny Walker didn't know that. So I'm going to come back to that in a moment. But first, ladies and gentlemen, let me talk to you quickly about the crime scene. Detectives come out. You're going to hear the investigation that they did at the crime scene. At the crime scene, they find Nilexia Alexander. They don't find a phone, but they find the cord that you saw around her neck in that picture, the charger, and they find a bottle of a drink that she was drinking at the time. They find a shell casing. They find some blood. They don't see much else. Nilexia Alexander is taken to the medical examiner's office where an autopsy is conducted. She is shot once in the shoulder that comes out through around the clavicle area. She is shot 3 times in the head. And again, one of those very close shot. The detective who was running the crime scene, who you will hear from, Detective Aaron Campbell, believes there's got to be something more out at that crime scene. Now, remember, when they're doing this crime scene, it's the middle of the night. It's dark. You could see how dark it was in that video. This is a dark, vacant lot. There's no lights. There's nothing to see. So he goes back out there. And when he goes back out there, you're going to hear that he finds 2 more casings. And he also finds 2 projectiles in the ground. All of these casings match up. They were all fired from the same gun. So 4 casings are total of found. So at this point in time, they eventually, because of a tattoo that Alexander had on her arm, they're able to identify her. So they start doing some research and investigation, and they find out that a few weeks before, Alexia Alexander had actually called 911 from a telephone. In that 911 call registers the phone number on that phone. So they began to do an investigation into that phone number. They find something amazing. After Alexia Alexander has been killed, based on what they've been able to determine as the time that she was shot, her phone continues to move. They're able to follow it for a while and are able to capture some videos of that car moving in specific areas where the phone was moving, that same black vehicle that you saw in that video. And they continue to follow where that phone seems to go on that evening, just after the homicide. And they follow it all the way to a Thornton's on Hillsborough. And at that Thornton, Thornton's, they see that car pull in. And they see this man get out of the car, out of the driver's seat. Ronny Walker. They now have a face. At this point in time, they haven't identified him, but they know that's the car. They know that car is there at the same time that Alexia Alexander's phone is there. And they now see a gentleman wearing this jacket, which will become important as well, getting gas. They also see someone get out of the passenger side. Again, they can't identify, but they know that there were 2 men in that car, the driver, Ronny Walker, and this passenger, who they will later identify as Robert Quincy Creed. So they continue to follow this phone. It's like a trail of breadcrumbs. And the phone leaves that Thornton's, and it goes to an area near where Alexia Alexander was when she was picked up. And it's there for a while. Again, at this point in time, they don't know who this is. They know they have a picture of this man. They have a general idea, description. They know the general type of car, but they don't know who he is. But they know that Alexia Alexander's phone has gone to this other location and it's there for a while. But here's another funny thing. The next day, that phone starts moving again. Ronny Walker still has not found out or figured out that that phone is still in his car. And so they follow it the next day. And sure enough, the next day drives through downtown Tampa, and they see it go to an area around Tampa General Hospital. The phone does, Alexia Alexander's phone. And so they were able to pull up Tampa General Hospital's license plate readers. And sure enough, there's a license plate reader there, and they see the car come through, and that license plate reader identifies the owner of that vehicle as Ronny Walker. Now they have a name. So they then attempt to locate Ronny Walker, and don't find him at first, But they noticed that the tag has a thing on it that says Giant Motor Sales. So they realized that it was purchased at a used car dealership, Giant Motor Sales. So they decided to go to Giant Motor Sales to talk to the person there about the purchase and see if maybe it has a locator on it or something. And when they get there, lo and behold, who is there but Ronny Walker himself? Turns out Ronny Walker worked there. Now, by this point in time in the investigation, the phone is no longer pinging. Clearly, the phone had been discovered and discarded. So they get there and they immediately meet with Ronny Walker, who proceeds to tell them various things that are clearly provable lies. He gives the wrong name of his girlfriend. He indicates someone was with him at Tampa General Hospital who they later find out was not with him. So they continue to their investigation. The car is at the Giant Motor lots. It's clearly impounded and taken into evidence. The car is searched. No phone. Alex Alexander's phone is not in that car. And they proceed to look for any evidence in the car, any blood, anything like that. And you're going to hear from a crime scene investigator who will tell you how they do that. And one of the things they do is this thing called Blue Star, which lights up kind of an ultraviolet light when there is iron or something that could potentially be blood in the car. And sure enough, on the back passenger driver's side, or back seat driver's side passenger, in the little area, when you open the door, that little door jamb area, they see what looks to be some sort of substance, and they swab it, and it tests positive for blood. That blood, ladies and gentlemen, is Alexia Alexander's blood. It was a mixture. It was an Alexia Alexander and Ronny Walker and some other unknown individual. Not Robert Quincy Creed, but some other unknown individual. But Alexia Alexander was the main one. They also learned that Ronny Walker at that time had a girlfriend by the name of Erica Sweet. He gave a different name for her, Erica Roberts or something, but her name was Erica Sweet. And they learned that he was living with Erica Sweet at the time. And it turns out Erica Sweet was only a couple of blocks from where Alexia Alexander was picked up. And also, interestingly enough, the phone, Alexia Alexander's phone, that whole night was in an area associated or where Erica Sweet lives and Ronny Walker lives. You also hear that another individual comes forward, a man by the name of Stanley Wilson, a man who has a significant prior criminal history. He is a man who sold fake insurance to people. And so he eventually got convicted of selling fake insurance to lots of different people. And so each one of those is a felony. So he has a lot of felonies. But you are also going to hear that at the time he was dating or seeing Ronny Walker's niece. In that he is kind of I don't know if the word is player, but he kind of knows the neighborhood, knows a lot of people, works with a lot of bondsmen. And he will tell you that Ronny Walker approached him one day and said, "Hey, I might need a bond." He initially tells him that Q or Quincy Creed shot a girl. But then he says, "No, man, it's me. I need it for me. I'm the one who shot her. Can you help me out with that?" And he tells Stanley Wilson that he shot her because she had given him an STD, or he believed she had. That was his belief, which he had then given to his girlfriend. The evidence, ladies and gentlemen, will show you that Ronny Walker picked up Alexia Alexander drove her to a secluded spot, shot her multiple times, including once in the face at close range, drove to the Thorntons with her phone after committing this murder, drove back home to Erica Sweet's house, where his phone and Erica Sweet's phone. And that's another thing. Erica Sweet had a phone also. Ronny Walker at that time didn't have a phone, but Erica Sweet did. His girlfriend, what he called her wifey. And that night at 3 a.m., sure enough, Erica Sweet's phone's moving. And it's moving along with Ronny Walker's car. And at a certain point, and you will see video of this, both Erica Sweet's phone and Alexia Alexander's phone are moving completely together. They're both in the car. And then they both come to stop at the residence of Erica Sweet, where Ronny Walker was staying. Ronny Walker tried his best to clean his car, but missed some blood. And that blood connects to Alexia Alexander and proves she was shot in that vehicle before getting out and ultimately shot in that vacant field. All of the evidence, ladies and gentlemen, points to Ronny Walker in that car. A car that on May the 6th of 2022, Alexia Alexander made the wrong choice to get into. And ladies and gentlemen, at the conclusion of this case, the state is convinced that you will make the right choice and find Ronny Walker guilty as charged of first-degree premeditated murder. Thank you.
Thanks,
So there we have it, guys. That's the prosecution's full opening statement to get us to where we're at today. They definitely presented everything that they promised us in that opening statement. Now we're going to go to, so just so y'all know, with the Stanley Wilson's testimony, they didn't like do the full testimony from the stream, but so we have a portion of it when the defense was doing a cross-examination. I'm not sure if y'all still if you still want to see that part, Benny, because they don't have the full testimony for him, but we have like where the defense picks up and cross-examines Ronny. They do, Stanley, my apology. Stanley. We also have the full testimony from Robert Creed. He's the one that described, how she was shot and how they got to, the scene and the things that they did after the scene. We have that testimony also, or we can go back to the closing statements that we heard on Friday. So you let me know what you would like to do. We got 3 options here. We can go to the closing statements that we heard on Friday and listen to those again, if you would like. We can listen to the defense cross-examines Stanley Wilson, or we can listen to Robert Quincy Creed's testimony, and he was the gentleman that was in the car. You guys let me know in the chat, and I will get it queued up, and we'll go right into them. Let me see here. I'm okay with whatever. I find them all fascinating, and just to see how they build these cases and actually get to the point of a conviction and showing jury. Because, of course, from the outside, we get to see a lot more. We get to see the news reports. We get to see all that information, and the jury just goes off of exactly what the prosecution, what the witness provide, and what the defense provide to make their judgment. Versus to us, we can kind of like judge them off of everything that we know. Like even with his prior conviction that did not come into trial, They didn't know that, but we knew that. So they were able to make this decision just based off the evidence that they received right there in that courtroom, which is really like, you know, great. And I'm so glad that they came to the right decision in regards to that. So let's see here. So here I pulled up the testimony for Stanley with the defense. I'll go ahead and play that. If y'all decide that y'all want to listen to something different, y'all let me know. But I'll put that on for right now. And y'all let me know if y'all want to change to me playing something different and us talking about it and seeing how we got to this point in the trial. Yeah. Oh no, I see it's frozen. Give me 1 second. I'm gonna fix it and reshare it for y'all can see it. Yes.
I don't know if it was specifically the day before, but it was during that time.
Well, haven't you previously testified that it was the day before?
Yeah, I said it was the day before or somewhere around that time.
You believe your testimony has been it was the day before or somewhere around that time?
Yes.
This conversation with the details, is that the same conversation where Mr. Walker was asking you about a bond for Q?
Yes.
Referring counsel to page 59 of that same deposition, lines 20 through 25. I'm sorry, hang on 1 second. You were asked, the conversation we had about Q, was that the day before he was arrested, he being Ronnie, near Ronisha's house? And you responded, yes, ma'am, because the same day that he was arrested is the same day that I turned myself into Manatee County.
Okay.
Those were the answers that you gave just a couple of weeks ago, correct?
Correct.
And you're referring to when you turn yourself into Manatee County sometime in May or April?
No, I turned myself in April, and then I turned myself in again July 7th.
I understand, but I'm saying when you're saying this conversation that you're having with Ronny Walker.
This conversation would have happened in July.
Oh, you believe it was July? Okay. Referring counsel to page 60, lines 4 through 7. During that same deposition, Mr. Wilson, you were asked, so you're saying Ronnie gets arrested in May, that same day? Answer, yeah, I think it was the same day that I turned myself in. Question. So this conversation that you had with Ronnie happened in May? Answer. It was whatever day he was arrested, this conversation happened the day before he was arrested. Those are the answers that you gave, correct?
Correct.
And it's during that conversation, the day before Ronnie gets arrested, that he's telling you he needs you to bond Q out of jail in Pinellas County or arrange for a bond for Q in Pinellas County, correct?
Somewhere around that time, yes.
Okay. Would you be surprised to learn, Mr. Wilson, that Mr. Creed, Q, actually doesn't get arrested until July 27th, long after Ronny Walker was in jail? Is that surprising to you?
Yes.
Okay. I thought it might be. I think your testimony to Mr. Terry is that Mr. Walker said he's arguing with Miss Alexander and he turns around and shoots her. Is that what you said?
Yes.
Now, you previously stated that Mr. Walker told you that when he shots Miss Alexander, she's sitting in the front passenger seat, correct?
I don't remember if he told me she was in the front passenger or not. I can't remember.
Okay. Now, you testified here today that you've never met Mr. Creed, correct?
Correct.
You don't know who he is, correct?
No.
Okay. But you were able to give Mr. Terry and the Detective Wieland,
Mhm.
an exact description of what Robert Quincy Creed looked like.
Correct.
Isn't that true? Yet
Uh-huh.
you had never met him, right?
Nope.
Never saw any pictures of him,
No, ma'am.
right? So you just miraculously knew what this man looked like.
No, I miraculously listened to what your client told me he looked like and gave that description was what he told me.
Okay. Oh, so this is some new information. Tell me more.
No, ma'am, it's not new. It's in my deposition.
Tell me more.
I mean, I don't know what to tell you, but that's what was told to me. I gave the description that was given to me in the deposition. If you give me the deposition, I can read it from that. I don't have it.
Oh, let me get that for you.
Thank you.
All right. Can I approach the witness counter?
Yes, ma'am.
Thank you. Mr. Wilson, I'm giving you all 90 pages of your deposition. Please let me know what page it is that you see where you told me Mr. Walker told you what Mr. Robert
No,
Quincy Creed looked
No,
like.
you asked me how did I know the description? I told you he gave me the
Right.
description.
Let me
Right.
know. Let me know in the deposition where you said that.
This is the deposition. I'm looking for the one from July from August 2nd of 2022.
You're asking for your proffer.
Yes.
Let me grab that from you.
Thank you.
I don't want all the papers to get mixed up, so let me make sure they're all in here. So I want to make sure that your testimony is clear because I think we got a little confused there. Is that your testimony today is that Mr. Walker told you what Robert Quincy Creed Sr., the father, what he looks like?
Yes, ma'am. It's in my, if you let me see the profile, I'll show it to you.
All right, here's your proffer from August 2nd. Let me help you, Mr.
No, I
Wilson.
have it right
You
here,
got
ma'am.
it? You got the correct
Yes.
page? And for council, we're referring to page 11, starting at line 10. Now,
Right.
Mr. Wilson, what you said
Mhm.
is that he was saying that when I gave them Q's son information, a description of Q's son,
Right.
is what he said he gave the detective.
Mhm.
And then you told the detective, not Mr. Walker, you told the detective because Q's son got that's after Q. He had dreads and was light skinned and had dreads, is what he said. But the daddy Q is a slim dude with bald head. That's you talking to the detective.
No, that's me
correct?
giving the entire description on what was given to me by him. I never stopped talking. That's just how they have it narrated in here.
Okay, so the court reporter narrated it
Yes,
incorrectly.
yes, correct.
Okay.
Judge, I'm gonna object to improper impeachment, and I'm gonna ask it just be read in its entirety. The question
I'll
being
sustain the
answered.
objection, we'll read the whole thing.
I read the entire. You want me to reread it?
She did not answer the
I
question.
didn't hear you reading it.
Okay. Do you know Q? Answer. I don't know. I don't know him, but I heard when me and Ronnie was talking, that's how I heard about him because he was saying that when I gave them Q's son, and this is in quotations. I gave them Q's son information, a description of Q's son, end quotations, is what he said he gave the detective. No more quotations are shown because Q got a son that's named after and said that Q had dreads and was light skinned and had dreads, is what he said. But the daddy Q is a slim dude with bald head. He ain't.
Approach for a minute.
We were objecting.
How much is standing objection?
All right, Mr. Wilson, referring counsel to page 81 of the June deposition, lines 21 through 24. You were asked, Mr. Wilson, okay, but how do we get a description of what Q looks like in your proffer given on August 2nd if you've never met him and you didn't know him? Answer, I don't know. Question, line 25, you don't know? And then I asked you about a news article. Do you remember that line of questioning?
Yes.
So I asked you specifically, how did you know what Q looked like?
Mhm.
And you had every opportunity to tell me, your client told me what he looked like. But you didn't say that, right?
Correct.
You said, I don't know.
Right.
Okay. Showing you a news article from July 15th, 2022. Can you have a look at that? And take a good look at it. Look at the contents of it. Have a read.
Okay.
And then let me know when you're ready to continue.
Mr. Vick?
Yes, sir.
Okay. I mean, okay.
Okay, hold on 1 second. Mr. Wilson, you've read that news article before, correct?
No, I haven't. I'm reading it now.
No? Okay. Oh, well, yeah, please finish reading it. Read all the information there.
Okay.
Your testimony shows you've never read that news article
I've
before?
never read this. No.
Is it a coincidence that every detail you just gave me comes from that news article then?
Objection, Your Honor, that's incorrect. And reproach.
Approach.
All rise for the jurors.
is he reading the article and when are you impeaching him? That's my threshold.
I would request that the witness be removed from
Yeah, could you take him out of there? Witness has left the room.
The reason this witness is reading this article is because he has seen this information in the news. I believe he testified that to Mr. Terry, that he has seen, that he saw information in the news. If he didn't, I'm sorry, I will ask that question. But this specific article was published right before he and or his attorney reached out to the state attorney's office.
Okay.
And it shares in that article the details about Miss Alexander being shot in the cheek, shares in there details about Robert Quincy Creed.
I don't disagree. But what I take exception to is for you to stand up there and say that every detail in this article, I think it is proper for you to go through the article and point out every similar thing that he has said that's in the article.
That's what I offered to do, Judge, is that if you want me, I didn't think the state would prefer me to do that, but if that is everyone's preference, I'm happy to go through the details.
That's what we're gonna need to do.
I
I
will
don't
do
have
that.
a problem with that, but you need to ask, you need to reiterate everything he said with everything that's similar in that article, but I'm sure that these are an article that he didn't say. Just because, even if he read the article, which he may or may not have, I'm not making a judgment on that, I'm sure he didn't recite every single fact. And for you to say that goes over the top.
Well, the point is, I want to make sure I'm clear. So the details that he gives about the shooting, right, about where the shooting occurs, that the girl is shot in the cheek, that Mr. Walker blames this on
Everything that he said.
the description, right.
But is
Those
that-
are all the details, by the way. None of those details differ. But I'm happy to go through each individual one.
Yeah.
That's not a problem.
Judge, I think after he says he didn't read it, that should be the end of it. If he had said he read it, then that's one thing, but he said he didn't read this article.
Then she could point out the eerie similarities between his testimony and those article facts.
That's not, I don't think that's proper impeachment, Judge. I don't know how that falls.
I don't think
under-
it's impeachment.
Well, so then what's the purpose of it?
Credibility?
It's hearsay.
It's not being offered for the truth.
Yeah,
of
it
the matter.
definitely goes to his credibility because it insinuates or it may lay the foundation for the belief that he read this article, called his attorney, called the state. I had a similar case as a prosecutor where the jailhouse snitch, his credibility was on the line. And they brought up everything that was in the article about it. But there was a deciding factor that made a huge difference in that case. But I won't go into that. I'm just saying that it's not improper and it's not unprecedented.
I think, Judge, I gave the witness my only copy of the article, so I just need a second to pull it up here, and then we're ready to go.
We can just make a copy of it.
Whatever is easiest. Let's see.
Yeah, we can make a copy of it.
Thank you.
You bet. I agree with what you're saying, but the way you came out of the block stating it, like you had memorized the article and point out the consistency.
I get it,
I have
Judge.
no problem with that.
I have no problem with doing that. That is my preference, to tell you the truth.
Yeah, I mean, because I think what's gonna become relevant also is you're claiming every fact in the article he said, so, but he may have said other facts that aren't in the article.
What I'm actually claiming is that every fact that he said is in the article, not everything in the article is what he said. I think there's a difference.
I understand what you're
Yeah,
saying, but he may have, I think he said other things that aren't in the article. But we'll find out.
Sure.
Are we ready?
Can I have just 2 more minutes?
Yes,
And
ma'am.
you can certainly bring the witness back in.
You can bring the list back. Thank you.
Okay, ready to go, Judge. Thank you.
Thank you for bringing the chair back. Unless there are any other matters we need to discuss before that.
Nothing else, Judge.
All right, very good, thanks.
All rise for the jurors.
Jury Scott, y'all may be seated. Thank you. Welcome back, ladies and gentlemen. No issues with the court's instruction, no discussions about the case or anything else. Very good. Thank you. Thank you. Maybe you're the counselor.
All right, thank you. Mr. Wilson, when we last left off, we were discussing the news article that was published July 15th, 2022.
Yes.
Okay. Now, you previously told this jury that Mr. Walker told you he shot Nylexia Alexander in the cheek, correct?
Yes.
This news article specifically mentioned she'd been shot 3 times in her head and once in her back, 1 wound to her cheek, correct?
Yes, I see it.
You told this court about the kind of car that Mr. Walker drove, a black Fusion.
Yes.
I'm sorry, Judge. I was trying not to do it. A black Fusion, correct?
Yes.
This article specifically mentions a dark black Fusion, correct?
It just says a dark Ford Fusion. It doesn't say black.
Okay, all right, a dark Ford Fusion. I'll give you that, right? You told this jury that Mr. Walker tells you that he goes to a Thornton's gas station immediately after, correct?
Yes.
This news article specifically mentions a dark Ford Fusion pulled into a Thornton's gas station at Hillsborough and Armenia Avenue, correct?
Yes.
You and I had this little back and forth about the description of Q, as in Mr. Robert Quincy Creed, the father, and Q, the son. Do you remember that?
Yes.
Okay. This article specifically mentions that Mr. Walker tried to blame it on Q, but gave the description of 6'1" with a slim build and dreadlocks. And that didn't seem like Robert Quincy Creed, correct?
Yes.
And that was the exact description that you and I were going back and forth on that you gave law enforcement and that you gave Mr. Terry, correct?
That's correct.
6'1", slim build with dreadlocks, right? Is that what you said in your proffer?
I don't think I gave a height, but
Hold on.
All rise for the jurors. All rise for the jurors.
Thank you. You all may have a seat. Welcome back, ladies and gentlemen. Again, no issues, no court instructions, no talk about the case. Only talk to you. Very good. I'm going to sustain the state's objection, and ladies and gentlemen, I'm going to ask you to disregard the last question that was asked to this witness and continue.
Thank you. All right, Mr. Wilson, so still on that article that we were talking about published on July 15th, 2022. Now, you told us here in court that a description was given to you of Hugh's son, correct?
Correct.
Okay, this article specifically mentions a description, 6'1" with a slim build and dreadlocks, correct?
Correct.
You told the jury here in court that Mr. Walker told you something about someone's cell phone being left in the car, correct?
Yes.
This article specifically mentions Walker's girlfriend's cell phone left in the car took a similar path as Alexia's phone, correct?
Correct.
All of those details that you and I just talked about, those are all in this news article, correct?
Yes.
All right, and it was shortly after this would have been published, so this is July 15th, shortly after that, that you have your attorney reach out to the state attorney's office, correct?
Yes.
And in fact, you yourself reached out to the state attorney's office by calling them to tell them you wanted to talk to them, correct?
Yes.
So you were pretty interested in talking with the state attorney's office, then, is that fair to say?
Yes.
little bit about your bond situation. You were about to have your bond revoked, correct?
Yes,
After you give your statement, that never happens, correct?
yes,
You had many cases that you were facing here in Hillsborough County that ultimately you pled guilty to. Was it in November of 2022 or 2023?
2023.
2023.
Yes,
And on your sentencing score sheet, you were scoring just under 10 years in prison is what your appropriate score should have been, correct?
correct.
And you pled guilty and you got a deal of 5 years in prison, correct?
Yes,
But that deal was conditioned on you being here to testify, right?
yes,
Because if you did not testify against Mr. Walker, the state attorney's office told you they would revoke their deal and you then would be facing 10 years in prison.
yes,
Okay. And not just facing, but that would be your sentence.
yes,
right? And that's your understanding as you sit here today.
yes.
I'd like to go back to something that you said here today, which is that Mr. Walker told you he turns around and he shoots Miss Alexander, correct?
Yes,
That conversation's happening during the first time that you speak with Mr. Walker at his mom's house or the second time at Ronisha's house?
I don't remember.
I'm going to refer counsel to page 58, lines 1 through 2. During that deposition that you gave just a couple of weeks ago, Mr. Wilson, he said he was arguing with her and they were in the car. She was in the front seat of the car next to him and they was arguing, correct?
I don't recall, but if you
Would
say
like
that,
to
yes.
see the
No,
transcript?
yes.
Yes?
No, I said, I'm agreeing with what you're saying.
But that's the statement you gave me
Yes.
just a couple of weeks ago.
Yes,
Is that Miss Alexander, Mr. Walker tells you, Miss Alexander is seated in the front seat passenger next to him.
yes,
And again, this conversation is all happening the day before Mr. Walker gets arrested.
if my recollection is correct, yes.
Well, you've previously stated, and we went through those statements multiple times, you stated multiple times during your deposition emphatically that this all happens the day before Mr. Walker gets arrested.
Yes,
And that's the same day that you turn yourself into Manatee County Jail.
yes.
Would you be surprised to learn the only record of you turning yourself into Manatee County Jail is from April of 2022?
I would be very surprised because I called Manatee County a few days ago to make sure that I had the dates right, and I spoke the records, and they told me exactly what day it was.
Okay. And did you call Manatee County to make sure you had these dates correct? Because Mr. Terry told you about the documents I provided to him.
No, Mr. Terry never told me about any documents you provided him.
No? Okay.
No.
Detective Whelan some information about a gun being thrown off a bridge?
Yes.
And you told Detective Whelan Mr. Walker cleaned his car, or told you he cleaned his car out at Thornton's gas station?
Yes.
And I believe what you told Mr. Terry is that
Can y'all hear me? Put a 1 in the chat if you can hear me. I'm trying not to talk too loud because I do got my mic volume up pretty high. Can anyone hear me? I know, right? You can hear me loud and clear, but I'm not what you want to hear, right? I don't know why the feed is coming in like that because we didn't have any problems with any of the other feeds. But check it out, right? This is what we're gonna do. I hope that everybody is like the video. I hope that you have subscribed to the video. Subscribe to the channel. I know that today's testimony for the Ronny Walker's penalty phase hearing trial has concluded. We do have another stream that is going to be streaming at 1:30. So like in the next couple of minutes, right? 4 minutes. I'll be sending the link out. And if you want to come join me over there, we're doing the Christopher Davis trial where we don't have a body. We just have a whole bunch of circumstantial evidence, right? And it looks like we're getting close to taking this case to a jury. So what I'll do is we're going to pick back up here tomorrow in regards to Ronny Walker, right? In order to see the next steps, if what the defense is going to present to save this man's life. Remember, you're always in the right place. This is Take It to Trial, where there are no fluffs, no filters, just facts. So you can be the judge and take it to trial. All right, guys, I will see you all over on the Christopher's feeds. We're going to catch up on that. See you then.